Good morning, everybody. Welcome to the, Enrique, are we, tape is rolling. Thank you. Flip the microphones. Thank you. Okay, we are recording and we're live for folks who are participating from elsewhere today. Good morning. This is the Monday, December 12th, 2016 meeting and hearings of the Colorado Oil and Gas Conservation Commission. Madam Hearing Officer, do we have a quorum, and would you call the roll, please?
We have to, sir. Commissioner Eggers? Here. Commissioner Dutton?
Here.
Commissioner Holton?
Here.
Commissioner Hawkins?
Here.
Commissioner Pierce?
Here.
Chair Spillman?
Here.
Commissioner Jolly?
Here.
Commissioner Randall?
Here.
Commissioner Wolf is not present. I understand you will be joining us later today.
Very good, thank you. So we have a quorum to take action. Very good. Thank you, Ms. Murphy. Commissioner, do you have a draft of the minutes of our prior meeting in your board packets? What's the commission's pleasure?
Move approval of minutes.
Second.
Thank you. We have a motion and a second. Any discussion? Hearing none. All in favor of approval of the minutes as presented, please say aye.
Aye.
All opposed, nay. The ayes have it, and our minutes are approved. Thank you. Report from the Executive Director's Office. Executive Director Randall, good morning.
Thank you. Good morning, Chairman Spielman. Good morning, Commissioners. I'm going to report a bit on where we find ourselves on the calendar today, and that is with an eye towards the legislative session. I first should say I'm going to stick around this morning through audience comments, and then I need to go to work on something because we have a big hearing coming up on Thursday with the Joint Budget Committee. So first, as far as the legislative session goes, I just wanted the commissioners to be aware. Our legislative liaison of the past 2 years, his name's Gaspar Pericone, has taken a different position and in the private sector and will be moving on. In fact, last week was his last day. We have a new legislative liaison starting on January 3rd, and his name is Doug Vilsack. Some of you might know Doug from his 5 years at Davis Graham & Stubbs. He's a CU law grad, and in the past 3 years, he's run the Posner Center, which is up in the Rhino neighborhood, sort of a clearinghouse and shared space for international aid development groups. So anyway, Doug starts beginning of next month. It will be a crash course in all things legislative. He knows our substance quite well and is going to be learning up the process. So anyway, I look forward. I'll ask him to come to one of the early commission hearings in January or February so that he can introduce himself and you all can put a face with a name. I'll just tease a little bit on the department's legislative agenda and highlight a couple of things that we're looking at pursuing. Some of this we've been waiting. We wanted to sort of finalize some of this after the elections, find out who the chairs of our committees of reference were and what the makeup of the legislature looked like. So now that all that's sorted out, first we will be looking at a bill to increase resident hunting and fishing license fees. This has to be done legislatively. The last time fees were raised was in 2005, and that did not come with a cost of living or a CPI index. So our spending power is down about 37% just by virtue of inflation and rising costs of things like, believe it or not, fish food and other sort of vital inputs into our programs. I just learned, just a quick aside, CPW did a program through the Whole Foods Cooking School where they tested 4 different fish foods in hatcheries and fed fish, from the time they were just small fry up until the point where they could be eaten. And then they did a taste test on which foods might be most, retain a good product because people who fish might want to eat their catch in a way that could save some money. So they're trying to get creative in looking at ways to save some of their save some of the hunting and fishing license fees. So anyway, that's bill number 1. CPW held 18 public meetings around the state this summer to educate people about some of their challenges and what it would take to maintain the level of service and even build on the services that they offer. And so that will all be incorporated into the bill. Second, I don't know the degree to which Matt's maybe talked about this with you all, but we're looking at a bill that would address the authority of the commission to go in and plug and reclaim an orphaned well. And also to foreclose on a statutory lien. So this is a, we believe, modest step to deal with the relatively small number of orphan wells, but again, ensure that we have the tools necessary and are precluded from going in and safeguarding these sites for the benefit of Coloradans when they've been orphaned. So maybe that's something we can, we don't have a bill draft yet. This is, again, these are just ideas that we've gotten a green light to continue talking about. And then finally, we're going to look at a bill to implement the water plan. In addition to the annual projects bill, we're looking at the possibility of a policy bill. And we haven't really landed on one proposal. We're looking at the possibility of extending Senate Bill 19 from a couple of years ago that would basically say if you're enrolled in one of these water sharing agreements, it won't impact your historic consumptive use. That would provide an assurance to some of the agricultural interests that there isn't a disincentive to participating in these state-approved programs. Another would be to try to address some of the costs of water court by sort of exporting the idea of there's a model on the Arkansas River for lease fallowing agreements whereby the parties can sort of agree beforehand that this model will sort of rule the day as to water loss and return flows and things like that. So the idea is potentially to export that idea statewide to, again, just eliminate some of the battle of the experts at the water courts if the parties can agree to a model beforehand. So that's kind of the legislative agenda in a nutshell, in addition to our annual projects bill, annual species conservation trust fund bill, and things like that. One of the biggest issues we're going to be dealing with this year is revenue. The department receives, department-wide, about 10% of our funding comes from the general fund, and that's it. The rest is cash funds, and a large portion of our department is funded by severance tax. And due to declines in price and production, we've seen some revenue challenges as a result of that. We have our joint budget committee hearing on Thursday morning, so this will be a topic there to be sure. I imagine one of the things we'll be talking about is Senate Bill 218, which put a restriction on certain of the department's unobligated funds in the operational account. And that was sort of a hedge against additional or larger than we might anticipate refunds related to the BP versus Department of Revenue case on return of investment deductions. So anyway, we're going to be talking about revenue a lot this session, I suspect. As a result of declines in severance tax, we're looking at zero new money flowing to Tier 2 programs in the next year. As for Tier 1, some of this will depend on the new revenue forecast that comes out next week. December 20th is the next revenue forecast. And we're actually hearing promising notes about uptick in price, potentially uptick in drilling, and the fact that many operators might have sort of used up some of their ad valorem credits in this last year, which has resulted in historically low revenue. And so we're hoping that the revenue forecast will be a little bit higher. So in those matters, I'm happy to take any questions from commissioners if there's something you'd like a little bit more information on. Maybe I'll just close out and steal a little bit of Matt's thunder by acknowledging both the departure and a retirement here at the commission, and just thank Dave Kuhlman for his service with the Oil and Gas Commission, and Nancy Prince. Nancy was here earlier. Where is she? Hi, Nancy. Thanks for your service too. All right.
Well, great. Executive Director Randall, thank you. Commissioner, and more on Dave and Nancy in just a moment, yep. I think, as well. Commissioners, questions? Let me say thank you also to Gaspar Pericone for the work that his service to the department, and as you were kind enough to introduce him to us last year, I think we'd like to take you up on your offer when, with the legislative calendar, it works for Doug to spend a little time with us as well. I've worked with Doug and think very highly of him. I think that's a great addition to public service at our state, and I know that our commission will benefit from his hard work, as will all the public. So thank you for sharing that good news with us as well, and we'll leave it there.
Okay, thank you.
Thank you. Director McQuarrie.
Thank you, Mr. Chairman. Good morning, commissioners and audience members. As usual, I just first want to commend the staff report to everyone for an update on what's been happening here at the commission. It is a thorough update of the highlights, and I'm not going to repeat all of them. I will focus on a few of them. I am dying to know if they tried lawyers as the fish food, possibly. It seems like such an obvious. Okay, never mind. All right. The first item I would like to highlight is that a work group came out of the governor's task force to work on recommendation number 37 of that task force, which said reduce truck traffic from oil and gas activities. The task force asked that COGCC and CDOT work together to come up with ideas about reducing truck traffic. That work group was co-facilitated by Dave Coleman, Deputy Director for 5 more days, and Kathleen Stacks from the Department of Natural Resources. Dave and Kathleen brought together a group of stakeholders that included a large number of local government representatives, industry representatives, transport carriers, CDOT staff, of course, and at least one engaged citizen. With that group of stakeholders, they held 3 day-long meetings to tackle the issues around truck traffic. And they kind of came to 2 paths. One was reducing the number of trucks on the road, acknowledging that that number is never going to get to 0. It's just not, or at least not in any real hurry. So there was the reduction, but then there was also the aspect of mitigating the effects or the impacts of the trucks that are on the road. After about a year of work on the project, they have produced a final report, and that full final report is available on the Commission website. So want to certainly thank Dave and Kathleen for their work in leading that group, and commend the report to everyone who was interested. Dave, do you want to add anything to that?
I think you get it all.
Okay. Another recent project is a collaboration with the Parks and Wildlife and COGCC to develop a tool, a database tool, to track mitigation measures for wildlife mitigation measures. So our rules require consultation with Parks and Wildlife when a location is proposed in either restricted surface occupancy or wildlife mitigation areas, which are mapped statewide. Our rules also require that when the Parks and Wildlife recommends mitigations, that if on private land, the surface owner must agree to those mitigations. The rules also don't require that COGCC adopt the mitigation measures recommended by CPW. So there's this bit of a dance, and the purpose of the tracker is to track what CPW recommends and then what actually gets implemented. And this all goes back to questions about the status of the greater sage-grouse under the Endangered Species Act. So with that, that tool is now available, and you're going to have a bit of a more detailed presentation from Greg Romano a little bit later this morning. That takes me to 2 pending staff departures that Executive Director Randall tipped my hand on, but that's fine. It was in the staff report too and elsewhere. So we are saddened to be losing 2 staff members. First, Nancy Prince. Nancy, would you wave, but you're short, so there you go. Red scarf is very helpful. Nancy, most of you know as one of the original 2 local governmental liaisons, right? Nancy and Mark Wharton were hired for that position when that position was created in 2012. And in that position, Mark and Nancy have really forged what the LGL program is, what it was, what it is, and what it has become. She has also forged really, really important relationships with lots of local governments up and down the Front Range. I often find out first what is going on in Aurora, Arapahoe County, Adams County, through Nancy, because of her relationships there. She has been with us since 2009 as a contractor in the permitting group. She took a full-time position in the permitting group in 2011, and then came on as the LGL in 2012. We've gathered, thanks to Ms. Murphy, a couple of insights, quotations, comments from some of the stakeholders with whom Nancy has worked. The Department of Local Affairs said, Nancy, I appreciate your consistent and genuine outreach to DOLA. and APA Colorado. From an operator, you have made a huge difference in bringing community and industry together through education and outreach. And from an LGD, while I'm in denial over your retirement, I wish you the best. This is sad news. They will not be able to replace you. So we agree we don't aim to replace her, but we appreciate her service and her time here. And her last day is the end of the month, yes?
Yes.
Okay. So thank you very much. In addition, as you have now heard, Deputy Director Coleman will be leaving us. And again, saddened that that has come to pass. Dave, I couldn't resist, apparently, a trip back to the industry where he will be with Synergy in a permitting and governmental relations executive director position there. I don't think I know anyone that has as much energy as Dave Coleman. He is on the go constantly, constantly in motion, and constantly directing that energy to getting projects done. And those projects here for us are numerous. They include leading 3 different lean projects for us in a facilitator role and delivering not only the product, but then ensuring that the product or the project was implemented, working with staff throughout the organization. And one of those, the field inspection report, Dave had a very insightful idea to invite industry to the lean process. So we had a lean process that involved both regulated community and the agency. And I think to great effect to team up with it that way. I've mentioned the truck traffic work group that Dave co-led. He also has been leading a technical work group on noise issues for more than a year now, about a year and a half. And that started around about the same time we were thinking about rulemaking on noise, somewhat in conjunction with the task force rulemaking. You all know that didn't come to pass. But part of the reason that I think we felt comfortable not moving ahead with the rulemaking on noise was because of the progress that was being made in that technical work group that Dave led. Dave has done a tremendous job with outreach to our operators, setting up monthly meetings with operators to go over a series of sort of compliance assistance. I think was the root of this, was helping operators, manage, work through the, I better be careful what I say, maze of our regulations, drafting and preparing a number of guidance documents, operator guidance documents. Dave led that effort with various managers throughout the organization. More recently, he has set up a small operator outreach team that is focusing on just the smaller operators who, may not have a permitting staff or a regulatory staff to keep up with our rules. And he has also been our point person with the Colorado office, governor's office, Colorado Office of Information Technology. So OIT, beloved to all of us. Dave has been the spirit catcher there for a long time. Just today, I was introduced to our new full-time data analyst person who will help with all of our IT projects along with our rather lean existing staff. So it's been not quite 3 years. They've gone fast because you're always in motion, but I can't really thank you enough and wish you the best of luck. Okay, I will close out with the rather banal Rule 318A subject matter. You asked us for a white paper on 318A, some of the issues we've talked about over the last 8 to 10 to 12 months, and we will deliver that to you at the January hearing. I will tell you that it continues to be an issue. These issues haven't gone away. We continue to see lots of different iterations brought forward by operators on spacing, on pooling, on numbers of wells and spacing units. There continue to be weekly, if not more frequent, conflicts between operators seeking wellbore spacing units. So again, I will only reiterate that I think, time is high for a pretty hard look at 318A, and that's what we want to kind of tee up for you in January. Thank you, Mr. Chairman. I'm happy to take questions.
Great, thank you. Commissioners. Let me just, I know I'm speaking for all of us in congratulating and thanking Nancy and Dave for your service to the commission, to the state of Colorado. And I hope that professionally our paths will cross. Dave, you might get used to sitting on, in that side over there, and you'll always be welcome. And all your service will be hopefully institutionalized and know it's appreciated, both you, Nancy, as well. I'm just going to say quickly, because it's more of a comment than a question. Sometimes our agenda is such that we have more people in the room at the beginning of the hearing than the end of the hearing, and that might happen today. So I do want to say something I might have closed with some hours hence, which was 2016 was a difficult year, a transitional year, an interesting year, a controversial year. And I want to, as I've done in the past, thank not only the COGCC staff, the commissioners, including our two new and one rejoining commissioner. I think we're got our sea legs under us, and we're operating as a commission. And thank you all for your patience. I also, just because it's the end of the year, I want to say thank you to all who participate in these proceedings, whether in person, via other types of communications. Even litigation is a part of the public's business. And I really believe that in Colorado, we disagree without being disagreeable in a way that many, many other places can't say. So I appreciate the professionalism, the exchange of ideas, and the privilege of working with everybody. I'll be right back in 2017. These chairs will all be full. But I did want to say sort of an end of the year thank you to all involved, on the chance that everybody who's here now may not still be here at 1 or 2 o'clock this afternoon. So thank you. That's my comment. Let's continue with other commissioner comments, please, if they are. Director, thank you for your presentation. Commissioner Pierce.
Thank you, Mr. Chairman. I have a couple of comments that occurred to me that I think I ought to add. First of all, in line with the chairman's comments just now, I think that the leadership that has been exhibited by our chairman, by the director, and by the executive director have not only helped all of the commissioners, but I think it has helped the industry, the public, and the state of Colorado. And I am grateful to the three of you. I know you're working hard, and I know it's not always fun. Certainly working with me is always fun.
Stipulated.
To follow on to something that Matt addressed, and I didn't join in at the time, particularly with regard to Dave Kuhlman. We have all worked with Dave for several years. He has been masterful in communicating and consensus building and trying to help industry and the state and the public work together. As others have said, I am deeply grateful for that. But I joined this conversation to say that that sort of communication and collaboration can be worked from either side. And I hope Dave and everybody in industry will encourage his new employers to allow him to continue to provide us those services because he does it so well. We really look forward to having him stay in the mix and to the extent he can exercise some leadership in that because we need it. So thank you, Dave. I join others.
Commissioner, thank you for those kind words and very thoughtful comments. Thank you. Other commissioner comments? Questions for the Director, the Executive Director? Commissioner Holton?
I just got one to address with Nancy. My staff works real close with her at the city, and it's really going to be, I know my staff is not going to be happy she's leaving. So I want to thank her for all the work she's done well.
You're here. Thank you, Mayor. Commissioner Randall?
I might take the liberty, just because I wear two hats, one as executive director and one as commissioner, to chime in here. A point that I intended to make but didn't during my executive director's report was in the discussion about the legislative session coming up. I just wanted to be sure that commissioners were aware of a couple of developments related to energy, and these are in particular on the Senate side. Senate President Grantham formed a new committee this year, and it is called the Senate Select Committee on Energy and the Environment. And this is not a committee that can refer bills, but rather can just have, basically, I don't know what all they can do. We will see what they take on. Senator Ray Scott is the chair of that committee. So anyway, it will be a forum in which our collective issues are likely to be discussed. So I wanted to be sure you were aware of that. And then second, on the Democratic side in the Senate, Minority Leader Guzman appointed Senator Matt Jones as the Senate Deputy Minority Leader for Conservation, Clean Energy, and Climate Change. Makes for quite an acronym when you write it out. But he will be, I believe anyway, a member of the Select Committee that was formed as well. So anyway, I just wanted to, I meant to mention that before. I wanted you guys to be aware. Thanks.
Thank you, Commissioner, Executive Director. Mr. Mayor.
Mr. Chairman, if I may jump in one more time. I think I need to confess something. And the Executive Director Randall mentioned that there's a move afoot to increase in fees. I feel like I need to confess that I may be, at least in small part, responsible for that. I think I may be one of the few in the room, if not the only one in the room, who's willing to admit to legally qualifying for senior status. A couple of years ago, I applied for a Colorado annual fishing license. And an annual fishing license for a senior in Colorado costs $1. I was stunned, and I was chatting at one point with Governor Hickenlooper, and I sort of jokingly mentioned that to him. And he got very serious, looked me dead in the eye and say, I'm gonna have to do something. To the extent, I apologize.
Thank you, Commissioner Pearson. Final comments? Okay. Well, thank you. Let's turn to the ever important audience comment portion of the agenda. And it over when I'm going to stall a minute while Hearings Manager Murphy. Ms. Murphy has our sheet. I'd like to get a sense, just for time management purposes, how many, looks like we have 3 people signed up to speak. Are there others, are there folks here today who would like to address the commission but did not sign? I see I'm being told there's 1. Okay, well, let's go with our customary 3 to 5 minutes and see where that gets us, please. Ms. Murphy? Good morning. Have a seat wherever either side you're comfortable, and of course, all speakers will just ask you to come on up, adjust the microphone so you're comfortable, and introduce yourself. Thank you.
Thank you very much. Good morning. I'm Wendy Hyvie of Greeley, Colorado. I'm a co-founder of the grassroots citizens group Well Air and Water. And I thank you so much for your time and attention today. You recall I was here at the end of the summer, and I spoke about my concerns regarding the proposed vetting site near Bella Romero Middle School. Once again, I have 3 and maybe 4 or 5 precious minutes within which to make a concise and I hope convincing statement. Usually I testify with regard to the things that I hold most dear, the health and well-being of my community. But recent circumstances have changed my priorities. Health and safety, though always important, now takes second place. The thing I value most is democracy and the participatory process that makes it possible. When I appear before you, I choose my words with care because I believe in this process. Director Lepore, the commissioners, and the COGCC staff has always treated well air and water members respectfully and as stakeholders in it. And I want to thank Nancy Prince for always making me feel welcome and wish her well in retirement. And though we do not have the resources and the lobbyists of an oil and gas corporation, it is this very process of stakeholder participation that helps to even the playing field. This process works best when each participant can rely upon and trust in the integrity of the other. And I have relied upon and placed my trust repeatedly in Director Lepore, Governor Hickenlooper, CDPHE, and COGCC, starting in January 2013 when Welder and Water was formed. At that time, my neighbors and I were dismayed that the Greeley City Council and Weld County Board of Commissioners balked at the state agency proposals to modestly increase setback distances. And over the next 4 years, while we have not always seen eye to eye, the members of Welder and Water have been grateful for COGCC's vigilant inspection program and its education efforts. We were pleased that our member Sarah Berwinski had a seat on the governor's oil and gas task force. Today I come to you with what I consider an emergency. The participatory process is being subverted in Weld County. Citizen stakeholders were not invited to participate in important planning meetings, and they've been excluded from input into the formulation of county regulations, officially called ordinance number 2015-26. We were dismissed as a flash in the pan, called, quote, an activist streak, unquote, in the local media. This turn of events obliterates citizen stakeholder involvement and entirely ignores the track record established by Welder and Water in its numerous appearances at hearings on the municipal level and state level, in meetings with agencies, and so on. Opposition to the county's approval of the vetting site near Belleville Grammar School is perhaps the progenitor of the Weld County Commissioner's citizen excluding streak. Prior to confronting the county about vetting, our focus was primarily upon urban locations within Greeley's municipal limits. This was not for lack of care about Greater Weld County. We are simply a small grassroots volunteer organization spread much too thinly. Given our limits, we have focused on sites in the most densely populated areas. And I have several newspapers that I'm going to make copies of and provide to you later as I spoke with Julie. I've got the initial Greeley Tribune story of November 29, 2016. The legal notice that was printed, read the ordinance, and that was on December 7th. And letters to the editor, also December 7th. And then the Tribune's, the Greeley Tribune's editorial board statement of December 4th, 2016. And that editorial board is quite centrist and very pro-oil and gas development. But those editors sounded the alarm regarding this threat to democracy and civic capacity. They were very, very concerned about the lack of for stakeholders to participate. Please know that the citizens of Weld County, including Welder and Water members, care and want to be involved. We are alarmed at this turn of events, and we know that you also value participatory democracy. We sincerely invite, or should I say, even plead for your help in these troubling times. The citizen stakeholders of Weld County, all 270,000 of them, desperately need you to protect their right to participate in the oil and gas siting process. The promulgation of Ordinance 2015-26 without citizen input is an anathema to our democratic process. And I welcome any questions you might have for me.
Well, thank you very much. appreciate hearing the good news part of that, which was the working relationships with the OGCC. And thank you for sharing that. I am one voice, but I know my colleagues feel the same way. The stakeholder involvement is so very important and is very valued in this room. So thank you for that and for your comments today. And we'll look forward to seeing the pieces that you're going to leave behind tomorrow.
And can I just add a few?
Please.
Yeah, I appreciate what you just said, and I want to acknowledge that I know it takes a lot of effort to involve community stakeholders. I would say we're a high maintenance group. It takes a lot of time to notify them and educate them about the issues. And so I know it's not an easy process. And I just welcome any ideas you might have for us. So I really, really would appreciate that. Thank you so much for your time.
Thank you.
Thank you, Casper.
Good morning, Mr. Chair, members of the commission. My name is Andrew Casper, Director of Legal and Regulatory Affairs with the Colorado Oil and Gas Association. I want to echo a lot of what was said by Director of Local Board Commissioner Peters with respect to Deputy Director Coleman's departure as from that role at the commission. Over the past 3 years, we've seen instrumental and significant strides in the areas of achieving regulatory certainty and operator outreach and operator engagement with all different bases throughout Colorado. And I know it was not an easy lift, and we certainly didn't agree that we stepped away. But that Dave's ability to understand the practical realities, operational realities of our industry was extremely helpful and led to some meaningful and significant changes, particularly with the lean process, with the multiple iterations of guidance documents. I think those were significant and well received among COGCC and industry alike. And I hope this type of engagement will continue over the next whoever replaces Dave in the future. I know there's worked with a lot of the staff, and they're very, very competent and looking forward to that type of engagement moving forward. With respect to, I believe Commissioner Pierce's remarks about continuing engagement, I manage our environmental committees, and certainly there can be an opportunity for Mr. Coleman to come in that respect. I also want to, so thank you, Dave, for all your work. Appreciate it and look forward to working with you in the future. Also want to acknowledge and thank Nancy Prince for her work on the local government level. We certainly, COGA has 2 local government outreach coordinators that go travel through the state, and they work with the local government liaisons. Tom and I have heard really, really good things about Nancy, and she will do this as well. So thank you for your time.
Thank you, Mr. Casper. Questions, commissioners? Mr. Coleman's workload is increasing and he hasn't even started.
We still have the next 2 weeks, so.
That's very glad to hear that. Thank you. Who's next, Ms. Murphy?
I'm afraid I can't read her writing. I believe it's June and last name starts with F.
Oh, I passed.
Oh, okay. Our final public commenter chairman is Derek Mack. Okay. No.
Good morning and welcome.
Good morning.
If you could please reintroduce yourself.
Yes,
We have your name properly.
Yes, thank you. My name is Derek Malmgren, and I live in unincorporated Adams County, in between 2 residents of Broomfield County. I am here today as a concerned citizen, a father of a 6-year-old and a 3-year-old, in the entire process of everything from permit to spacing to all of the planning that goes into some of these processes. Right now, as everybody I'm sure is aware of, with extraction, oil and gases, proposals to come into the city of Broomfield. It was originally understood in the initial negotiations with the original owner of the rights and drilling process, that there would be a memorandum of understanding, I believe, with the city and county that explained what was going to go into that area. And since then, there's been a very large discrepancy with what the process is going to be moving forward. I live within a half a mile of that area. I've never received any letter. I've never received any information that this was happening. Nobody in my neighborhood has. We're not from one of the two largest densely populated neighborhoods, but anything I found has had to be through highly investigatory means by myself. Right now, if 140 wells are proposed into this area in near proximity of one existing school, one planned school, the city's proposed drinking water reservoir, I think that it's unacceptable, and I think that the practices of increasing this amount has become ridiculous. I also am concerned about even the permitting process for this. I know that between the 4 well sites, there was 4 different public hearings. One of them was a 4-hour round trip distance from where the proximity of the drilling would take place at 9 a.m. in the morning. I think that is absurd to imagine that a general citizen is going to be able to get to that if they could even know about it in general. And I have a very high concern about basically major industrial complexes going into highly dense residential areas. So I'm just in the process of learning how all this is working now. I'm taking time out of my work, time out of my family. I was a very moderate individual my entire life. I've never even been able to declare into a party. So I'm the middle ground that if these practices continue, will be moved in one direction or the other ground, as I would imagine a lot of Colorado is. So my request would be that there is, better information, and I have seen some improvements, I think, to the COGCC website with some of the tracking, the permitting process. I think it's great what is going on there. But with the advancements that have been made, even going and talking to another kind of open house, I believe, for Western Energy, they described the fact that the drilling process has gone from the ability to go 1 mile to 3 miles. I don't know, the truth of that, but I do know that it does not need to be this large scale in proximity to drinking water, in proximity to schools. And I have a high concern, and I would just hope that when these processes are taking place, and especially when there was an MOU with the existing city under a certain understanding, that wouldn't be changed after the fact. So when you go through the process, I'm not even sure where you are in the process of determining spacing or determining appropriate well sites. I would hope that you would consider the citizens, many of which that don't even know the extent to this entire operation.
Thank you, Mr. Malmgren. Question before you head out, let me ask Director, could somebody, as Mr. Malmgren is learning more about our public processes, could we make him aware of resources available, local government designee in his county, and various tools that all in the public have available to learn about the processes underway of concern, of interest?
Thank you, Mr. Chairman. Yes, of course. I think a little bit of background, and forgive me if I sponge on some of the smaller details. Mr. Geronimo's in the room, can help me out if I need it. The locations in question, as Mr. Malmgren expressed, are extraction oil and gas well locations in Broomfield that have begun to have been through a Broomfield city and county process. So the city and county of Broomfield essentially approved the locations, which does go back to the prior agreement with Sovereign, who was Extraction's predecessor. Sovereign had 10 approved oil and gas locations. Those were planned for vertical or perhaps directional wells. We all know how things have evolved over the last several years, and so what Extraction did with the city and county of Broomfield was negotiate to eliminate those 10 planned sites and consolidate them onto 3 horizontal well pads in a location that the city and county of Broomfield approved. One area that I know there's been a significant misunderstanding or disagreement about are the number of wells that extraction intends to place on those wells. Just for clarity, I want to say that I'm speaking of 3 wells, 3 well pads, because they are the 3 that replace the 10 vertical wells. There is a 4th well pad that extraction has inherited, acquired from Noble. So from the, I think, a citizen's perspective, there are 4 extraction planned well pads. And extraction has told us they plan to drill up to 40 wells from at least 2 of those pads and 140 wells from the total of those 4 pads. That is a correct number. Those 40 well pads, we have met independently with extraction. Well, let me say that again. We have had a meeting jointly with the city and county of Broomfield and extraction oil and gas to talk about just what I'm telling you. The wells planned will be 2-mile long laterals, to the best of my information, from the pads going both north and south. So you will have 2-mile laterals reaching to the north, 2-mile laterals reaching to the south from these planned pads. It's clear that in the negotiation process, it's clear in my opinion, and I should be careful to say that, that the city and county, when they approved these locations, did not anticipate that density of wells to be placed on these pads. And I think there was some misunderstanding, but I wasn't there, so I'm not going to say anything on that. I think the other thing that's important for the commission to understand and the audience to understand is that we don't have those permit applications from extraction in the door yet. I think there is a spacing application or 2 from extraction perhaps on the docket today. Not on the docket today, it's been protested by the city and county of Broomfield. So we're sort of, from our process, Mr. Malcolm, we're pretty early in the process. What has gone on in the public sphere has been the city and county of Broomfield's process for the most part. Extraction is in the process of lots of planning still with, I would say, still a significant number of moving parts. But I've told you, what I understand to be true, 4 pads, a total of 140 wells, I haven't said why, and it's perhaps better that extraction say why in an appropriate place. To answer the chairman's question specifically, Broomfield City and County does have a local governmental designee. In our world, we look to that person to be the point of contact to the community, to the citizens. And I don't know the ins and outs of Broomfield's process, and maybe we can connect you with somebody here from our staff who could elaborate on that for you. The LGD from Adams County is in the audience, and perhaps if you haven't met him, we could make an introduction there. Our process is permit driven. When extraction submits permits to us and they've been deemed complete, we will notify the LGD, and that notification will trigger a public comment period. It is typically 20 days. There are circumstances under which it can be extended. And that's really where we are seeking public input. These locations, for the commissioner's benefit, are on a lot of people's minds. We, staff, myself, Greg, others, Julie, permitting staff, we get emails from citizens. I had thought there would be some members of one of the neighborhoods in the audience today, and there may well be. We have invited them to come in and meet with us tomorrow. I haven't gotten caught up on all my email traffic, so that may or may not be confirmed, but we will meet with that particular group of citizens. We have previously met with a group of citizens from the Wildgrass neighborhood, which is another neighborhood in some proximity to these proposed sites. So that's kind of where it is in our process and what I know about it. And there are lots of staff here in the room and myself, and Greg, if you want to visit more, I'd be happy to tell you more.
Well, thank you, and I definitely appreciate that. Coming from my own perspective, being in one county, being between, another county, another city, especially being on these border areas, it's, it magnifies the amount of research you have to do it exponentially to even keep up with it. And when you go by township, range, all of these different aspects, if any layman has ever tried to search, where that pinpoints a location, it's impossible without subscribing to costly GIS software. And I have seen some improvements through your website, I think, that helps locate those. But I know it will be a challenge moving forward with the growth of Colorado, the growth of the industry, and I do think there needs to be a delicate balance. And I'm coming from a moderate standpoint in life. A lot of what I do is moderation, and I expect that from the general public to live a society where everybody benefits. So I appreciate your time today and everybody's time for their involvement in this and reaching out to neighborhood associations or cities or towns, whoever it may be. So thank you very much.
Thank you very much. Director?
Hey, Mr. Chairman, thank you. Just two real quick points. I do want to first thank you for saying nice things about our website. It doesn't happen that often, so it's fantastic. And we are trying hard to make it better. And I want to tell you about one thing that we've done very recently that I think makes it vastly better for the public, and it's called our daily activity dashboard. If you go to our homepage, up on the right, upper right-hand corner, it says that. Also says DAD, because that's the acronym. That is a new tool on the database that sorts information by county. So Broomfield has a checkbox there, and it pulls data out of our database in 7 different topics, including pending permits. And so with that tool, if you'll just look at it, it gets updated every single day.
And how new is that tool?
That tool is about 6 weeks.
Okay, and that's where I've briefly been able to look at that, but I would say that's where my comments of compliment have come.
Right.
Because before that, you would not have heard a compliment.
All right, fair enough. Steady, slow, steady, slow, steady.
So thank you, and I would encourage anybody to look at that. I haven't had the time right now to go into that. I just saw that new resource the other day, and I think that's a good step forward. Thank you. Thank you very much.
No, thank you. Are there other members of the public who wish to make a comment at this point? Hearing none. Commissioners, shall we move on to our next order of business? Which will be our consent agenda. Ms. Murphy, I think I will ask probably on your behalf. Well, let me first ask, any changes to the proposed consent agenda today?
Yes, sir. At the request of an applicant and more protesting parties, docket number 1610-00414 is the only item in group M has been continued to January hearing. So there is no need to vote or consider on group M, which is a Highlands application, docket number 1610-00414. Other than that, I don't have any changes.
So that's continued to January. Thank you. Commissioners, disclosures, recusals, or other comments? Hearing none. Shall we proceed?
Mr. Chairman, if I may,
Let me call the Vice Chair, Commissioner Minton.
I move that we approve consent agenda items A through O with the exception of M, which has been continued for the next year.
Second.
That was eight.
Clarification. Through P as in Papa. Okay, through P. That was a I apologize, I just
Skips over the next page. A through P, the motion is for approval of A through P with the exception of M. Motion amended, does the seconder agree? Thank you. Discussion. Hearing none, all in favor, please say aye.
Aye.
Opposed, nay. Hearing none, the ayes have it. Those items are approved. Thank you, Commissioners. Remaining on the consent agenda, we have Enforcement Group A, What is the commission's,
Motion to approve.
Mr. Chairman, if I may.
Please.
I would ask to modify Commissioner Holton's motion to approve to exclude docket numbers 1610039 and 161000458. Vote on those separately. I'd like to recuse myself from those two items.
sorry, thank you, Commissioner Bennett. Beg your pardon while I catch up. Those are the docket numbers again, please. Was it
161000390
390
and 161000458.
458? Two related to Marilex. One is Marilex Resources, Inc., and the other is Marilex Disposal, LLC.
Yes.
And 161000308 remains.
That one also, please, thank you.
Thank you. So that would be three items related to Marilex entities: 161000308, 161000390, and 161000458 would be pulled from the consent agenda. Commissioner Holton, would you like to amend your motion?
Yes, sir, I would.
And I will second that amended motion.
Thank you. Commissioners, the motion and the second are to approve all items in Enforcement Group A with the exception of the two docketed items from Marilex Resources, Inc. and one from Marilex Disposal, LLC.
Sorry.
Thank you. Any discussion? Hearing none, all in favor, please say aye.
Aye.
Opposed, nay. Hearing none, the ayes have it, and those items are approved. Do we have a motion on the three Marilex docket items?
Move approval of those three Marilex items.
Second.
Thank you. Motion is made and seconded. Commissioner Benton will not participate in this action. Any discussion? Hearing none, we'll call the question. All in favor, please say aye. Aye. And opposed, nay. Ayes have it. And those are approved as well. The record will reflect Commissioner Benton did not participate in that action. Very good. Thank you. Commissioners, shall we continue? Thank you. We have, I'll turn it over to Ms. Murphy for our first general hearing, please.
We have docket 1610-00475 and 1610-00478. Are the first here, right? And then hearing officer Ross will be here to introduce the particular chair.
For folks listening to the broadcast, we're just taking a moment for the parties and their representatives to take position at the tables and prepare their materials. you.
Good morning, Commissioners. I'm Jim Rouse, the hearing officer on this matter. In each of these cases, Extraction Oil and Gas LLC proposed designated horizontal wellbore spacing units pursuant to Commission Rule 218A E5A. Pursuant to Commission Rule 218 E5B, PDC Energy Inc. objected to all of the proposed designated horizontal wellbore spacing units. Extraction has sought a hearing on PDC's objections in accordance with the provisions of Commission Rule 318A E5C. Both parties have filed preliminary statements and written testimony. Preliminary statements and written testimony have been provided to you in your portfolio. A participative pre-hearing conference was held before the hearing officer on October 12, 2016, with other staff members and the director also participating. Witnesses for both parties were questioned, and attorneys for both parties made oral arguments. Unlike our usual application process where the applicant, not the protesting party, has the burden of an objection to the creation of a wellbore spacing unit, Rule 318A E5C provides that it is the objecting party that has the burden of proof. That means in this case it is PDC that has the burden of proof before the hearing officer. The hearing officer has issued a recommendation which has been recently provided to the commissioners and the parties. That recommendation is to dismiss PDC's objections. So according to the rule, the commission has two options at this point. The commission can vote to uphold the hearing officer recommendation. In that event, PDC's objections are dismissed. This means that the applicant Extraction is free to submit its APDs and proceed with administrative creation of the units. The second option is for the commission to reject the hearing officer recommendation. In that event, both cases will be set for an evidentiary hearing on the merits, probably at the January 31, 2017 commission hearing. At that hearing, after weighing the evidence, the commission has the option of approving the units as proposed by Extraction, or approving modified units, or denying the proposed units altogether, or issuing any other relief the commission feels is appropriate. So this morning, after determining if any commissioners have a conflict of interest and need to recuse themselves, PDC will present its argument first. PDC will have 15 minutes for its argument, between its initial argument and rebuttal argument. Extraction will present its argument after PDC finishes its initial argument. Extraction will have a total of 15 minutes for its argument. PDC may then use the remainder of its allotted 15 minutes for rebuttal. The commissioners may ask questions of each party during their respective presentations. Time spent by the commissioners asking questions and providing an answer to those questions will not count against the party's allotted time. At the conclusion of PDC's rebuttal argument, the commission can close the record and then engage in deliberation and make its ruling. That's what I have for you.
Thank you, Mr. Rouse.
Mr. Chairman,
Commissioner Benton, is it you?
could I ask?
Please.
I'm sorry, Mr. Rouse, I just can't write as fast as you read.
Oh, sorry. I thought I was going slow.
Remember, third grade level. Would you please repeat what our options are with respect to if we reject the hearing officer's recommendation?
Okay, the hearing officer's recommendation is rejected. Both of these cases will be set for evidentiary hearing on the merits, most likely at the January 30 and 31, 2017 commission hearing. It would be a full evidentiary hearing with witnesses and everything there. At that hearing, after weighing the evidence, the commission has the option of approving the units as proposed by Extraction, or approving modified units, or denying the proposed units, or issuing any other relief that you feel is appropriate.
Thank you, sir.
All right, well, let's proceed. Murphy, do you think in the time, or Mr. Rouse? Or?
Morning, thank you, Mr. Chair.
Good morning.
Members of the board, commissioners, thank you for your time. My name is Michael Jewell, representing PDC Energy Incorporated, Burns, Fegan, and Will in the Tech Center.
And Courtney Shepard, also for PDC with Burns Fegan and Will.
Welcome.
Thank you. We appreciate the time and effort put forth so far by hearings officer Rouse and also opposing counsel. This is a case of first impression as we're seeing the horizontal wellbore spacing rule under 318A be brought into, if you will, the 500 series rules for this type of hearing. And thank you to Ms. Murphy for shepherding that process, and that's been good so far. But as you heard the director say already this morning, this matter of the horizontal wellbore spacing is not going to go away. I think this one is particularly legally and factually intensive, and it demands further hearing from you. It's a question that begs before you not only the analysis and decision of law illuminating this 318A, but it's equally a matter that informs how we as an industry in the great state of Colorado, a state that's vast in resources, but also progressive in balancing those competing issues. We do well at that. So I think, given time to beat Colorado in this issue, to come to some resolution, would be beneficial without resorting to a harder use of the law. And as stated before, in my understanding from permitting, these types of objections occur with some frequency. So again, I think this issue is important for you to consider, and also important for you to consider hearing in greater detail that come January. So before I get into the bones of our disagreement with the hearing officer's recommendation, I want you to know that both parties can see a path forward. We are here before you today seeing things a little differently, but it's a little different in that we are not collectively banging our heads against the wall trying to figure out if something can be done. We know we can. It's a matter of backtracking that into an agreement that works for both parties. So again, another just fundamental reason why this should be heard in greater detail. If you have the hearing officer's recommendation before you, I point you to page 2. The hearing officer recommended that PDC raise technical objections under the rule. The hearing officer pointed out that PDC agrees that extraction plans will not in and of themselves cause waste as to their proposed developments, but believe that PDC failed to produce sufficient geologic and engineering testimony to show how extraction's operations would cause PDC to leave significant reserves stranded in the ground. Well, this finding causes some confusion because PDC submitted no fewer than 10 geological exhibits, 6 engineering exhibits, both replete with the quantitative analysis that you deserve to see and demand to see in these types of proceedings. This is in addition to 6 additional and supporting land and business development exhibits that hinge on the technical merits. And in contrast, as your materials will show, there were only scant technical exhibits from extraction and also no rebuttal to PDC scientifically based fears of waste for their own production, their own development goals. And if you haven't seen a plat, just real quickly, I think it's fair to say there are a west trending application before you for extraction to drill from a similar site, surface site that's off of their wellbore spacing units. The PDC would also like to do the same, just trending east to keep that image in head. Well, I believe these exhibits need to be seen by you. The amounts of effort put into them will show that there is a considerable risk for waste and a denigration of correlative rights. That is precisely what the Colorado Oil and Gas Conservation Statute demands that this body look at. How do we prevent waste and make sure that mineral owners see the greatest return on their real property? And I think those exhibits will give you wonderful detail as to how we can avoid that risk. However, the more critical concern in the hearing officer's recommendation is the statement that PDC did not raise an objection to extraction on the grounds of ownership. You did put a footnote that indicated our trending toward that, but I believe that if you read our objection and also our case in chief, the issue of ownership is supremely important in this matter. I agree with the hearings officer that the definition of owner as stated now and also as piggybacked with 318A doesn't contemplate the ownership of the surface, but it's very important to know now that, in 2012 or so, when this rule came about, we didn't see how today we would do so much drilling off of the actual spacing unit, lands adjacent to it. And so we have to take into account what the law says about the use and the securing of those surface rights before beginning operations for those horizontal wellbores. You have to have unencumbered surface access as a condition precedent before you can drill these wells. I think that's logically important, that even if the rule is silent on how to treat, how to analyze surface use, I think you would agree that logically you have to have the ability to drill from that off-site location. You'll hear from Extraction today, I'm sure, that they procured an SUA from the current surface owner. However, this is key. PDC already owns the senior rights to use that surface in oil and gas leases secured back in the 80s, back when the estate was still unified, has since split to surface and mineral ownership. And why is that important? Without getting to the case, the statutory law would be better suited for an evidentiary hearing. A practical, imperfect, but a practical way to look at this. We've all probably had a loan on our homes, mortgages, maybe a second mortgage even for various reasons. And there's a reason why that second mortgage always comes with substantially higher interest rate. Because the purchase mortgage, the one that carries most, if not all, of the debt on that property, has the senior right under which if it clears out that entire equity in case of foreclosure, the junior owner is left with nothing. Well, in this case, in 1982, when PDC secured that lease, it got the senior lien, the senior easement and access right for those lands. And just because we have had a wonderful legal history since 1982 regarding surface and reasonable accommodation does not mean those rights have gone away. These are real rights and ownership under real property law. In the pre-hearing conference, Extraction explicitly stated that PDC acquired an SUA from the same surface owner, ostensibly taking a different position than us. They promised that at that time, Extraction would further negotiate with PDC for a solution to share the use of that same surface location. PDC, I believe, doing the right thing and being the reasonably prudent operator, decided that even though it has the senior rights, we'll go down that path and see what it can do as far as securing rights from the current surface owner, doing whatever it takes to satisfy Extraction and to make sure that we can be a leader and share this surface and have both companies do well to develop their respective lands. Now I'm asking for your vote today to set aside the hearing officer's recommendation and set this for an evidentiary hearing where you can hear more about that law, see more of these technical demonstrations. I have 3 points, and I'll end there. Number 1, the legal issue points to a critical oversight in 318A. As you know, it was designed, well, 5 years ago. However, it incentivized a race to the permit in a deleterious manner. Despite its good intent, it's taken us 5 years to see we have this juncture, this cramming traffic jam with the Wellbore Spacing Unit, and now we're seeing these important legal issues come to a head. So despite everything else that's going on for 318A, this issue right here is illuminating one of those key concerns. We are an owner as defined by the rules. We cannot turn a blind eye to the practical reality that the regulation fails to address. And that pit that rule creates needs to be addressed so that more owners don't fall into it. Secondly, the pages of second to this first point, the geologic and engineering testimony are detailed, have wonderful analysis and quantitative approaches that I think you would appreciate, especially given the number of you who have oil and gas backgrounds. The conservation statute demands that we prevent waste and protect relative rights. That's exactly what we want done. Number 2, and probably most critical here, discussions are ongoing. As I said before, Extraction asked PDC if we would approach the current surface owner. Not only have we done that, but we have, even as late as this weekend, secured a letter of intent to get that done. So we are moving toward that surface use agreement. Number 2, there is a roundtable discussion slated to be held this Thursday with Extraction, the surface owner, and PDC to see how we can get to next. Number 3, we have submitted to Extraction and they have yet to deny a CDA, a compatible development agreement. The beauty of which says this: you have these rights, we have these. Can we iron out the matters of timing and safety? And I know the commission doesn't want to see 2 large operations colliding because of a miscommunication about time. This is exactly the type of document that lays that out, independent of any further regulation. It says, we can do this together. You go first, PDC, you go second, Extraction. So how can we get there? That is still being negotiated right now, so it would be far too premature to dismiss our claims at the moment. And lastly, process and predictability. Again, we have fundamental agreement that we can get something done on these lands. So we're not knocking heads against the wall, like I said, for a resolution that exists in fantasy. There is a resolution. We admitted to each other we can share. So we want to move forward and do it and not let this dismissal get in the way. And secondly, continuing appeals. As I said before, thanks to Ms. Murphy for shepherding this into one area of the rules to the next, but I don't think we want to see this go dragging on and on and on for the different layers of appeals for a case of first impression. It would be better to let the parties continue what they're doing, get to the agreement they come to or not, and let that be it. The bottom line, the power of mutual agreement lasts longer than the force of law, especially when applied prematurely. So we humbly and respectfully ask that you set aside the hearings officer recommendation so you can hear this issue in full and make a truly informed decision. And even this request is in line with the manifest expectation that we will have a resolution before then anyway. There's so much more to know, and I believe Colorado has proven a spirit of determination and cooperation in this industry. Let's see that be proven here again. I'll yield any balance of time.
Thank you, Mr. Jewell. We go now, Mr. Rouse, to extraction.
Yes, extraction will have 15 minutes.
Thank you, Ms. Willis. Whenever you're ready.
Thank you, Chairman Stone.
Of course. Come on.
Good morning, and fellow commissioners. My name is Rob Willis. I'm an attorney that works for Shaner Group Law Firm. I'm here on behalf of Extraction Oil and Gas with regards to this issue that's been brought before you. Also seated with me at council table is Drew Stout. He's landman for Extraction. He's been bird dogging this issue for months. I have the luxury of having been on the commission when this rule was first being rolled out, and then I left to go into private practice. But I remember having discussions with then Director Neslin, also IT Manager Kerr at that time as to what this rule was going to look like and what was being contemplated by this rule being threaded into the rule book. It was the hope that the rule would lend itself to expedited processing for permits, the establishment of overlapping wellbore spacing units for horizontal projects. I think we've seen that have utility over the years since it's been folded into the rule book. I think Mr. Jewell is correct that we're seeing some angst with regards to that. You had a presentation at your last hearing in October by Mr. Kapoor and now IT Manager Stanzik regarding perhaps some tweaking of the rule that needs to be made, that there are ongoing disputes with regards to how these lands are going to be overlain and how these horizontal wells are going to be put in place. That may happen in the future, I suppose. Maybe that's something that's going to happen. That's not the state of the rule now. The state of the rule is very, in my opinion, even though it, when you look at it and do your first couple of reads through it, it might be confusing. I think it still has utility for the parties and for the operators. These wellbore spacing units for the double clutch project and the Adams project, 800 acres approximately in unit area, which overlap, were originally noticed some 6 months ago. So I would submit to you that this utility of this rule with regards to the timely and efficient processing of these wellbore spacing units and the subsequent APDs has been frustrated. And when I look at the frustration, the cause of frustration, you know, what I see as an attorney is basically abuse of process with regards to PDC. Everything that they've brought with regards to their objection deals with this concern about the competing surface use. And from my client's perspective, this may work out between the parties involving the third party. We can't forget the fact that the surface use owner is not here because they don't ever have an opportunity to be here. They haven't objected to this project. They haven't come in and they don't have a seat at this table. You know, this may work out between the parties in several months or whenever it works out. But it still stalls the process for my client, which in my mind, as an attorney representing them, leads to economic waste. You know, Extraction's a big publicly funded company now. They've got many dollars that they're trying to put into their their projects. They're trying to balance rig availabilities. They're trying to decide how and when they're going to do these projects. And having this unknown for these lands is a great handicap to them. So I think it's important that you look at that too. So, when I look at Rule 318A, again, I heard Mr. Jewell, I think in his remarks, and I think this was consistent with what I heard at the administrative hearing that we had on this, that PDC doesn't have an issue with the number of wells that we're going to be throwing into these lands, the numbers of wells that extraction is going to be throwing into these lands, which go from the west of the proposed surface location. And they don't have any problems with correlative rights. They understand the definition of those rules, and they didn't present any material which took issue with that. If Mr. Jewell or if PDC has problems with how this rule has been rolled out and is being used, what they need to do is make an application for rulemaking and see whether or not they can get something in the rule which talks about the surface location and whether or not there is competition at the surface and whether or not that's grounds to have an objection put in place and have a hearing with regards to an issue that PDC doesn't have an issue with. The number of wells. These are necessary wells to develop our lands to the west and adjacent to the surface location. I mean, it just confounds me as somebody was part of the process when this rule was written as to how PDC is attempting to bootstrap this issue of surface use into the downhole development of these lands. And when you look at the material, I know you've had it in your portfolio, you'll be able to see that PDC has been consistent with regards to their issue and their frustration, their concern, and it's been this competition over the surface location. It has nothing to do with either prevention of waste or protection of correlative rights. And I would just say too, if PDC had an issue with this, with regards to waste and correlative rights, you would have seen that type of material in your materials with regards to our project lands as to how we were going to be either promoting waste or abusing correlative rights, and it's not there, it's devoid. There's been no irregularity in the administrative process in this matter. I think it is kind of first impression for you as commissioners. And I certainly appreciate Mr. Rouse's work in bringing the parties together for this contested, and I'll term it a contested administrative hearing, which took several hours in my recollection, and Director McClure was there and Ms. Murphy was there, as well as other junior members of staff were there to kind of get their arms wrapped around this. And we looked forward to the hearings officer recommendation, which I think is a very nice piece of work, and I think it's important that you as commissioners support your staff with regards to how they deal with these issues and how they balance the rule and the showings that were made to them and what were supposed to be to them as they decided whether or not the objections that were placed by PDC should be upheld to the point where we have a hearing in front of you, or whether you support the recommendation and you dismiss objections as being basically meritless because they really don't address the objection that they're required to make, and that's the waste and correlative rights issue. I don't have any further remarks. I know I think I have plenty of time left, but I'll just waive any other additional time I have, and thank you for your consideration.
Of course. Thank you, Mr. Wilson. We'll keep time there. Rebuttal from Mr. Jewell.
Yes, it's a rebuttal from PDC at this time.
Mr. Jewell, Ms. Shepherd.
Thank you.
What's the time limit?
3 minutes and 20 seconds.
Thank you.
Yeah, thank you very much. And briefly to those points by Mr. Willis, is I don't think it's prudent as a matter of equity to have to resort to a more drastic and oftentimes hard rendering measures like rulemaking or something like this. You have the authority to determine the equity of your own rules, to decide how that should be placed. Because in this case, Extraction has the junior mortgage, if you will, on the surface. We have the senior. You can't just say that, hey, it's not explicitly in your rule about service, and therefore you're making a meritless argument. It's condition precedent. You have to have those rights secured. Right now, if they have rights, they are secondary to what we own. And since Councilor Willis admitted at least twice that this just might work the next coming weeks or months, or when we come back before you in January, that's the better way for this to be resolved, not using a large sledgehammer to rulemaking or even litigation over the very pointy-headed legal issue. I think we can get this done now. I think we can do it outside of this court and certainly outside of district court or anything else more drastic like a rulemaking. So with that, again, I encourage you to look at the fact that discussions are ongoing. We have signed documents toward what Extraction had requested that we secure. We have a meeting plan. We have technical discussion that's held about just how much resource be left in the ground. Something this commission should not ever see is proof that resource is left in the ground. So with that, I'll give the rest of my time. Thank you.
Very good, thank you. Shall we close the record, commissioners?
If there are no questions from commissioners, you go ahead and close the record this time.
Let's take commissioner questions, please, to either the applicant, to either PDC or Extraction.
What about asking questions with respect to some of the technical materials that were provided?
It's in the record.
Yeah, it's in the record, that's for me, but this is, Sal is a full argument for the attorney's not a fact. My position and that thing, questions of purposes, I think that's what things are on.
Okay, and yeah, my question is just go to some of the technical materials, so just for some clarification, so.
It's fine if you want a lawyer answer to your question.
I'm reminded of the fish food comment.
Well, remember, Mr. Rouse advised us that a reversal, if we do not accept the hearing officer's recommendation, the next step would be a full evidentiary hearing, probably at our next commission hearing. And at that point, Commissioner Benton, I think that exactly it would be the topic. It would be technical matters, not simply or solely the legal argument for today.
Okay. This would be not necessarily a question for either esteemed attorneys that are present representing the groups, but maybe perhaps for director clarification. What I heard during the discussion was that there might actually be some possibility that this gets resolved and replace Solomon again. If this is, we end up rejecting it and moving it to the hearing in January, it may actually get resolved between the two parties in that period of time. Is that something that's ongoing, or maybe Ms. Murphy could shed some light on that? Is that a possibility that may happen in that period of time? Or maybe even the attorneys can weigh in on that? Commissioner, I guess I don't feel it's appropriate for me or staff to speculate on the status of the interactions between the parties. We are not informed. I cannot comment on what will transpire based on your decision. Okay, so I apologize, maybe it is a question for the attorneys. I start with Mr. Willis. Do you think that there's some possibility that this gets put into January to get this resolved? And my concern goes back to some items that were presented in the evidence about some concern about changes in the drilling program that might affect the ultimate recovery from both areas and potential morality rights issues. And I think this might get resolved.
Thank you for the question. I don't know. I don't know. I don't think my client knows. He's here. He's part of the process. These documents that Mr. Jewell referred to, I haven't seen those documents, Commissioner. I'm not sure what they say. I'm not sure whether we're close to resolving this issue. I know there are talks which are presently scheduled for this week. The length of those talks, the duration, the substance, I'm not sure of. I would just want to point out the following issue. This was originally to be brought to you in October, at the October hearing in Sterling. And Mr. Jewell made a request of the hearings officer that it be continued. And it's been continued now for 6 weeks for the purpose of attempting to resolve this. The parties haven't gotten together yet to resolve it. So, I mean, for my client's position again, you know, it's important that you focus on the rule again, that you look to see exactly whether or not we've conformed with the rule with regards to the material that we've provided, and whether or not the objection that PDC has provided you has merit. And you know, we would say no, and I think your hearings officer found the same. So hopefully that answers your question from at least the extractions perspective. I don't know.
It does. Thank you. Mr. Jewell?
I would suggest that Council Willis did not say no, but I have definitive times where the CDA was sent and accepted and discussed between authorized persons at extraction and with my client. Also, the letter of intent was executed over this weekend with a third-party surface owner. That's a hard document that says we are intending to move forward to secure an SUA ultimately after this Thursday meeting. This Thursday meeting has been agreed to by members of Extraction, PDC, and this third party. So I think I can tell you very straight-faced, Commissioner Nixon, that we have the meetings that are in place that can get to an agreement well before the 7 weeks that we need to get.
So then a question for Mr. Rouse. If we go with, it occurs to me that even if we approve dismissal, there wouldn't be anything that would stop the two parties from continuing to try to work together, come to some agreement to get development that's sort of mutually developed. What it would allow extraction to go forward with filing their permits to drill wells.
I think that's correct, yes.
Thank you. Yeah, go right
Yeah,
ahead.
please.
If you were to reject the hearing officer recommendation today, it doesn't tie your hands. You may hold a hearing next month and reach the exact same conclusion that hearing officer Rouse reached and enter your own order finding so after a disputed hearing. The other statement I wanted to make, I think it was in the Oak Creek matter a few months ago, you heard a oral argument just like this. And you closed the record and instructed the parties to try and work it out. That's another option you have. In other words, at the next meeting, you would make the decision that is pending before you right now, instead of making that decision right now. Which,
Our question is that there was some concern about kicking the can down the road.
that's what you're doing for a month. Yes.
Yeah.
I think that's right, but we did kick it and the road ended with magically an agreement between the parties in that case. But I think legally that's an important reminder. That is a third option available to the commission today.
Yeah, I did remember that one. Thank you.
Commissioners, other questions of Council for Extraction? Mr. Willis, you had your hand raised before.
Oh, I did.
Something pertinent to the
I hope it is.
question that was already out on the table?
Yes, it's just something that I forgot to mention after consulting briefly with my client. Whether or not you dismiss this objection today, which obviously you should, the meeting will still occur and we'll still work towards resolving this outside of the commission's hearing process. We're not going to use that as an opportunity to foil PDC's plan to occupy lands with us. We'll continue to work in good faith towards bringing forth that resolution with the surface owner. But once again, it's important that we get these permits in queue so we can start, planning our projects.
Thank you, Mr. Wilson. Mr. Jewell, Ms. Shepherd, anything kind of final word, but indirectly in response to that comment?
Just directly in response, we do have a printed timeline of events, and to Mr. Wilson's comments, you will see a significant acceleration in our discussion the moment that the objection was filed. So for that reason, I believe our objection is proper to keep the fire under the feet, so to speak, to get this done. Thank you.
Thank you. Okay, commissioners, if there are further questions, please indicate it. If not, I would suggest we close the record and begin our deliberations. And then let's do so. The record for this matter is closed at this point, and we'll begin commissioner deliberation.
I'm
Very, very courteous commissioners.
Yeah. So this is again, I'll have to, perhaps there's, the biggest concern I have here is from an engineering background, I don't understand all the legal ramifications of this, but I'm left with a question that in searching through all the various rules, I never saw anything that specifically spoke to a junior versus senior right to surface access. And did get some clarification from the AG on this, Mr. Matter on this. And I don't think that exists, so then if you sort of put that into that, that's all we're here to rule on today, then it's a fairly simple decision. And the question I've placed to the other commissioners is if we approve dismissal, it would sound like that there, that gives Extraction the opportunity to go forward and file their applications. Doesn't stop anything from the two parties from working together to try and resolve their differences. And perhaps, well, Mr. Jewell, it might turn up the flame a little bit to encourage them to get this done and go forward. So that would, I'd ask for any other commissioner comments on this.
Yeah, Mr. Chairman.
Please, Commissioner Pierce.
I appreciate that, Commissioner Bent, and I, reading over the materials that were forwarded to us and listening to council this morning, I'm of at least two minds and perhaps more than that. One of the thoughts I have that have been discussed is it might be wise to kick the can down the road. To allow operators who are willing and able to make investment to develop Colorado's natural resources to work things out might not be a bad thing for the commission to do. And I'm conscious of that. Both parties have mentioned this morning in argument that they are continuing these discussions, and they think those discussions may very well be fruitful. And I think the commission ought to pay attention to that. Director Lepore mentioned during his presentation this morning that there is some level of, perhaps I can say, consternation about 318A. It is continuing, and it may need to be addressed in the future, and I'm aware of that. And so that's half my brain, those kinds of things. The other thought process that I have really arises more out of the reading that I did rather than listening to council this morning. I think, and the commission's council can feel free to disabuse me of this notion, but a couple of things occur to me. Number one is Extraction has filed an application to drill some wells. Extraction has submitted for this record proof that it has a lease / option to purchase agreement with a surface owner, which specifically allows them to drill a well on a surface location to develop resources not under that surface. That's what I think those documents say to us. That I believe that the surface owner has the right to authorize someone to drill from a surface location, even if the minerals are owned by someone else. Now, PDC points out to us that we need to worry about waste and correlative rights. But as I understand the record, extraction does not propose to develop any mineral resources under the surface in question. Now, if extraction were found to have fracked a well under that surface, I would have very serious concerns. If extraction were found to have fracked a well inside the forbidden zone for the drilling and spacing unit, I would have a lot of trouble. But if the surface owner has entered into a surface lease with extraction, which allows them by its own terms to drill a well to an off-lease location, I think they have the right to do that. And my reading of the record that we have before us now and just indicates to me that it's okay. Now, I don't have a problem, and that's the other half of my brain. If I misunderstand the legal positions, I hope somebody will swear me away, because that's, and if I'm correct, if the surface owner has the right to enter into that lease to allow somebody to drill a well, and extraction is only going to deplete the well to produce minerals for which they have leased, I do not find PDC's objections well founded.
So,
Commissioner Benton. Thank you, Commissioner Pierce.
so a couple of comments. I don't comment on the legal piece, just clarification. The extraction has yet to file APDs to drill wells. Depending on what we do today, we'll forward and file those applications. Since you raised that question about drilling, I agree with you that the surface owner has the right to execute an agreement with extraction to go drill wells on a surface location and access extractions minerals without going into the minerals released to someone else. In reading those materials, the concern I got in me was that there was some evidence presented that says that based on that surface location, it may result in some potential waste or correlative rights issues because it pushes PDC into not putting optimal locations in place to develop their own minerals, which are underneath that surface. However, there was some more evidence that extraction showed, which showed their anti-collision presentation that demonstrated that potentially they could. Which then that, where I got to is that piece about if we reject the dismissal, then we go to full hearing and we get to see all that technical discussion. But I tend to be right with you in the same place, though, that there's nothing that says in there that says if the surface owners execute an agreement, there's nothing to keep extraction from proceeding ahead because they have an agreement with the surface owner to go drill their wells.
And if I may, Mr. Chairman.
Of course.
It also occurs to me that as I understand the state of Colorado law, and I'm not a Colorado lawyer, but as I understand the accommodation doctrine, as the mineral lessee, the PDC has to accommodate the interests of the surface owner over its mineral acreage. That surface owner has entered into a lease which allows the use of part of that surface for something very specific. I'm concerned that the sort of junior versus senior discussion that you were bringing up, Commissioner Benton, leads us to a place where a mineral owner could claim that a surface owner could put a barn in a particular location because maybe the mineral owner would want to drill a well from that location sometime in the future. That's not the way I understand the accommodation doctrine, so I think it's incumbent on PDC and the surface owner to work together, and to the extent we can, allow the surface owner to allow that lease to continue.
And that gets into a place where I don't think we have any predictions over that surface, so I guess that would be a question for our commander. And I agree with you that that's where that is. It's sort of a slippery slope for me by going down to that, because it goes back to the surface owner and said, I signed an agreement that says my surface can be used to put this well pad and we'll drill these wells. And it does potentially harm the mineral development, but that's a bit of a gray area. And I think you really want to go down that place, and we may not have jurisdiction over that, the surface rights and what the surface owner can do with that. So I guess that would be a question to have, Mr. Matt.
Commissioner Pierce, nothing you said from a legal standpoint causes me to want to correct you. I think you've accurately summarized things. You know, the notion of due regard is reciprocal. The surface owner must reasonably accommodate PDC's surface acreage and vice versa. So with respect to your question, Commissioner, then do we have, let's say the PDC lease specified this particular surface location where PDC's wells were to be situated. Could you nonetheless authorize extraction to place, develop this acreage in reliance on a surface agreement that specifies the exact same location? My answer to you would be yes, because you are not here to litigate the difference of opinion between PDC and the surface owner. So PDC's, the gist of PDC's argument is the surface owner has sold a property right, which it doesn't have. And you are not here to litigate that property right.
Mr. Chair.
Please, Commissioner Holton.
My opinion is it worked last time by kicking it down the road. It sounds like they're pretty close to a deal anyway. So let's kick it back to January. As much as I'd like to have another hearing and listen to 3 hours worth of testimony from lawyers and engineers, I think we can just go ahead and kick it down the road and see if we can get something done.
Thank you, Commissioner Holton. I'll share my thoughts. Great discussion, and I don't disagree with anything I've heard today. The issue, as I understand it, is does the protest, is it meritorious based on the fact that waste would be caused to PDC's development of hydrocarbons by what we believe might be extractions plans, although no APDs have even been filed yet. And Mr. Rouse's recommendation seems predicated on the fact that there hasn't been sufficient technical documentation of that reported waste to meet the standard. And I don't take issue with that, but to me, that is what would come out in an evidentiary hearing. And we would be focused where the Oil and Gas Act puts us on whether this is where waste would occur and can be avoided or not by virtue of our actions. So I am inclined, to either reconsider our action in January. I would like to do that, I think, because I am hopeful that the parties would come up with a conclusion other than what we're hearing today. And if not, frankly, I'm prepared to use our precious time for that evidentiary hearing and see if the allegations of waste are supported or not. But I'm one of 9, or in this case 7. Director.
Thank you, Mr. Chair.
Now he's gonna correct me.
I feel it's important for me to clarify procedural point on the APDs in this case. Under 318A, when an operator files for the wellbore spacing units, it has to certify, if it's true, of course, that there were no objections. If there are no objections to the wellbore spacing unit, the operator would file APDs at that time, and our approval of the wellbore spacing unit automatically approves the APDs.
By virtue of no objection.
By virtue of no objection. Here, there was an objection, therefore it's inappropriate, fruitless, pointless to file the APDs. So I'm concerned that the way it was being characterized, and maybe I'm misunderstanding how you're characterizing it, but I don't feel you should feel that extraction has not taken a step that they could have taken by not filing the APDs. I think that's procedurally clear.
Thank you, Director. I think that's understood. Okay, I appreciate that.
I was just being OCD, just to make sure we're clear what had happened, but I do understand. Okay, thanks.
Commissioner comments?
No problem.
Please, Commissioner Hager.
Yeah, I think I agree with Chairman Spielman. If we are specifically looking at protection of correlative rights and whether or not it's causing waste, the evidence in the information and packets that we were given, as Commissioner Benton pointed out, say 2 different things about the correlative rights and whether or not PVCs are protected or not. And I think if those are the 2 specific things we're looking at, we need a more technical presentation.
Mr. Benton.
Yeah, so I'm asking, would you like to motion something to the effect of what both you and Commissioner Hager brought forward? Or do we just move to just the proper one would be to reject the hearing officer's recommendation for dismissal of these, which then sets the hearing for the technical thing?
I don't believe we have a motion on the table.
Question for council, if I may.
Please.
Thank you. I would ask council or staff, if they can, to give us a sense of what difference it makes whether we reject the hearing officer's recommendation or delay decision on the hearing officer's recommendation.
As a practical matter?
Yes, as a practical.
So, if you delay the decision on the oral argument today, you could potentially have 2 more hearings. So if you delay today's decision and instruct the parties to come back next month for the ruling on your decision, you could instruct them to be ready to go either way. Ready to go on the merits. In other words, if you reject Mr. Rouse's hearing officer recommendation next month, the parties should be ready to try their cases. That's it. Right then.
So the motion would be to continue the next month?
Yes.
So moved.
So again, if it gets continued the next month, then that potentially makes us have 2 hearings, correct?
That, it can be continued.
Yes, continue with the proviso.
Instructions to the parties.
Is that what you intend? Yes. Just as the AG outlined, be prepared to have the full-blown hearing next month, if they don't come to a deal between now and then.
So record remains closed. We have a report from staff as to whether there's any new developments between the parties that might obviate that next hearing. or not?
Well, even if they settle, or I'm not sure,
Mhm.
just to advise the commission in advance, yeah, you would be well aware of if it settled. But I'm sorry, I don't think I was very clear, Commissioner Hawkins, do you have a question?
Commissioner Hawkins.
If I could. Yeah, it appears to me that if we just continue the case, then we still don't have a requirement to have a technical presentation next month. I mean, I think it sounded to me like that we need to, if we want to have a technical hearing, we should reject the hearing officer's recommendation.
The alternative would be to require the parties to prepare for a hearing that may not occur. You could do that within the first 5 minutes of the next hearing. In the first 5 minutes of the next hearing, you could accept hearing officer recommendation and there would be no hearing.
I understand.
I believe
That
that
might
is,
be
that is
expeditious.
the sort of amended motion that
That's on the table.
Mayor Holt.
But the only thing I wanted to point out, I listened to all of the commissioners' comments, and I agree that I think with the surface owner's approval, that Extraction has done their work to get the approval to drill wells. But I think with the allegation that there's going to be an infraction of correlative rights, that it is incumbent on us to at least address that. I think it would be a mistake to not listen to someone's concerns over their correlative rights. So that would be where I would go with this. But I do understand that we can defer a decision, and then next month we have the option to either hear the case or the hearing or approve the hearing officer's recommendation at that point.
Well, thank you, Commissioner Hawkins. We do have a motion on the floor. I don't know that it's been seconded. It has not.
So the motion from
Commissioner Holton.
I'll second that motion, but with a request that someone please read it.
We'll look to Ms. Murphy and Mr. Matter for one of you to put into the record and make it clear to.
Motion to continue the decision on the present oral argument with the instructions to the parties that be prepared to go to hearing at the next monthly meeting.
So that would mean that if we reject at that hearing, and if we reject the hearing officer's recommendation, we would immediately go to a hearing, a full hearing, full evidentiary hearing. And I will second that motion.
We have a motion and a second. Is there discussion?
Further discussion, if I may.
Mr. Pearson.
I understand the motion, I understand the sentiment. But it also feels to me as if we're judging protection of correlative rights under acreage that is not being proposed for development. And that is worrisome to me in the sense that it's too uncertain that the correlative rights that are being proposed for development are the correlative rights of Extraction and any other mineral interest owners in the proposed drilling and spacing units. And to affect that development based on some adjacent correlative rights which are not under consideration makes me uneasy, but perhaps we will confront those questions on that. So I just wanted to lay that one out there for people to think about.
And I absolutely agree with you. It's one that I really struggle with because your barn example is a great example of that. And that we're having a discussion around correlative rights for future potential development of minerals underneath the surface where these wells will be drilled. And I guess, is that tie back to what we need to do with respect to revisiting all of 318A. And getting into that, because that is, a barn has a much smaller footprint than a surface location with a bunch of oil wells on it. Which does give me a lot of cause. Some loss of sleep anyway over this whole discussion.
These are great issues, and I'll just call on myself for discussion. You know, when Mr. Jewell said this is a motion, an issue of first impression, that's the first signal to kind of hold on to your seats here. It's not going to be easy. It never is when it comes to us. I am going to vote in support of the motion that's on the table. I really am, I don't know if concern is the right word. I don't believe I have the information that I would expect to come out in the evidentiary hearing to understanding that PDC still has the burden of proof to demonstrate that waste, that harm to their relative rights. And I don't believe I have that information at this point. So I'm going to vote in favor of the motion that's on the table today.
Call for the question.
Further discussion? Okay, everybody understands the motion. It's been seconded. All in favor, please say aye. Aye. Opposed, nay. Thank you. Ms. Murphy, do we need a roll count? That was pretty quick.
I believe that everybody voted aye except for the speakers.
Very good. The record will reflect that neither Commissioner Randall nor Wolk are present in the room, but we maintain the quorum, obviously. Okay. Parties, please work with our staff to prepare for January. Commissioners, thank you for a very important and robust discussion.
Give us a Christmas present. Get this thing
Thank you. We are a little behind schedule, but I'm going to suggest just a 10-minute break, and we will reconvene. I wonder, commissioners, let me ask, we just did a general hearing. Should we have, for some reason, we have these two URU presentations and then another hearing. Should we do this, should we reorder this a little bit and do the next hearing and then get into presentation mode? Are the parties here, Ms. Murphy?
I believe they are the one. I would ask maybe we should also move the bill bearer to review first.
No.
Julie, it's okay.
Oh,
Okay,
great.
we're going to come back in 10 minutes and Ms. Murphy will tell us what we're doing.
Maybe we can do staff presentations.
Welcome back, Enrique, we're ready to go? Very good, thank you. We are a few minutes behind schedule, we'll make it up. Let's continue now with unconventional resource unit presentations. This is order number 4071457, involving Weinberg Field, Weld County, and the operator is Bill Barrett Corporation. I see Ms. Fulcher and Mr. Lonsdale in here. Mr. Rancy, I'll turn it over to you to tee this up properly.
Thank you very much. Good morning, Commissioners. My name is Jill Devancy. I'm the hearing officer for the 2 unconventional resource unit annual reviews scheduled for the docket today. As you may recall, in October, Schwinn held their unconventional resource unit review, at which time they indicated to you that they had not fully developed any of their units and requested that they would be terminating 12 of the remaining 13 unconventional resource units that they held. That application was on the consent agenda for your consideration this morning. Although the Schwinn units were the first units established, those unconventional resource units were not developed, were not fully developed, nor were they made a priority by Schwinn. For those commissioners who are appointed after the last unconventional resource unit was approved, the goal of the unconventional resource units was to allow an operator to fully develop a designated area without returning to the commission and requesting additional wells. The operator was permitted the appropriate number of wells based on its own internal geology and engineering information. The operator would be required in exchange to present to the commissioners each year until the unit was fully developed. Today, Bill Barrett Corporation is presenting on their unconventional resource unit a 1920-acre unit, which was approved last October. Bill Barrett Corporation has been given the same reporting requirements as the development of all of the other unconventional resource units. A copy of their PowerPoint presentation has been provided to you, both a hard copy as well as in your portfolio. Bill Barrett Corporation will present on order number 407-1457, the order establishing the unit. This is their first annual review. On behalf of Bill Barrett Corporation.
Thank you very much, Mr. Rancy. Good morning, Commissioners. Jill Fulcher with Beatty & Wozniak here today on behalf of Bill Barrett Corporation. And with me is Mr. Ken Lonsdalen, Senior Vice President and General Counsel for Bill Barrett, and he'll be walking you through BBC's annual report. Mr. Rancy teed that up very nicely. This is BBC's first annual report to you following your approval of the 1,920-acre unconventional resource unit last October. And those lands that are comprising that unit are sections 10, 11, and 14 of 6 North, 62 West. So with that, I'm going to pass the baton to Mr. Lonsdalen, and he will explain to you what BBC has been working on thus far for operations within the new room.
Thank you, both Jills. Team that up so nicely. The rule around Mr. Rancy, she's Jill number 1, that's Jill number 2.
And I'm okay with that.
So if you go to your first slide, this is basically what we were facing when we started looking at this project, saying drilling spacing units in those 3 sections. And one thing to note is because we had existing drilling spacing units, all of which had wells in them, holding acreage by production was not part of the goal of forming the unconventional resource unit, which I think is a distinction that probably can be made between what Axiom originally tried to do but wasn't able to follow through, probably primarily because of price declines. So in any case, we had acreage held by production. We have 3 640-acre drilling units you see on the left side there, and 1 1280 on the right side. And we looked at this and said, how do we make this work? We've got these wellbores going different directions. We've got a mix of shorts and long. I will tell you that these are first generation Bill Barrett wells. They're not particularly great wells, probably never pay out. Since we have, several years later, these were drilled with sliding sleeves instead of plugging perf, fewer completion stages, less proppant, didn't use controlled flowback. So now we're ready to go back to this area and do it with a modern configuration. So that's the setting we have. So what have we accomplished since we appeared before you in October of last year? Well, the first thing we had to do is get this unit pooled. We started down that path by, following the order and the cooling rules. Oh, I'm sorry, I'm jumping ahead here. So let me go back to the order we got. So as Ms. Schulter said, we do 3 sections, approving the appropriate number of wells. That order provides, this spacing order provides that production be allocated based on the underlying spacing and cooling orders until we have pooled the first new well is completed. At that point, production from all the wells will be allocated based on the URU configuration. Let me say on that point that, as indicated, these original wells are not great wells. Going forward, 98% of the reserves to be produced from this unit will come from the new drills. So we want to have the dog wag the tail rather than the other way around here. And also, what we're going to do here is provide those working interest owners, and you go back to here, if you were in the short lateral 10 but didn't have an interest in the short line 14, but you'd like to come in now, we'll let you in now, just going forward. No retroactive contribution to capital. You can just come in on a go-forward basis. These wells are cash flow positive. So if you want to come in, that's your option. You don't have to. So that's the option we're providing to all the owners. And as Mr. Rancy indicated, there's an annual review required. So here we go. So the annual review now is what have we completed. And this is the work that we've done. So as I started off saying, we sent our AFEs and our offers to participate to the owners. We had one operator who decided they'd rather not be in the URU, and we worked out a swap of acreage with that operator, which was to our benefit. We got a better working interest. They got a better working interest in where they want to drill. And we got the pooling order from you in June 2016, and that was consistent with the drilling spacing order in terms of the allocation of production. As I indicated, we've been learning a lot about drilling these wells. We've evaluated production from the wells that didn't work too well, wells that are more recent and work better, and redesigned what is the appropriate number of wells to drill out here. So we have submitted APDs for 4 extended reach laterals. I'll show you the map here shortly. Those APDs have been approved, they're ready to go. We submitted APDs for 9 mid-reach laterals or MRLs, and also 10 or spacing, and I hate to bring that term up, boundary well, and I'll show you that on the map. Those are all in-house and pending approval here. So here's the map. We've got 18 wells essentially in the URU. 4 of those are existing producing wells that don't have much left in them. So if, sometimes you get these well bashing issues and you come back in and complete your wells, here really won't be an issue in this unit. 4 XRL wells on the east side of the unit, those permits are approved. 9 MRL wells on section 10 extending into section 11, toes going right up to that one of the early short laterals. And we do have the 10th well right along the boundary, southern boundary of 10. That's a well, we're spacing a well that will not be part of the allocated production to the URU, but it is being drilled from the same well pad as you see those 4 southern MRLs. So it makes perfect sense to go ahead and get all those wells drilled when we have the rig in place and get them all completed at once and avoid the well interference problems that we might have. We have space for 3 or 4 short reach lateral wells down there in the west half of 14 at some point. They're not included in the well count. I'm not sure if or when they get drilled. Pretty much at this point, as with most operators in the basin, if you can drill on SRL, you drill on SRL and SRL. So they're not on the 3-year drilling plan at this point. So we have 4 existing pads out there. We are only constructing 3 new pads. Forget exactly how many we had authorized, up to 8, I think it was.
You had 12 pads.
We had 12 pads authorized, we're only going to have 7. And we're going to utilize the 2 of the existing pads for production facilities
that you see circled in red. So we'll be expanding some of the production facilities at those. And the only new production facilities is that one that's circled, so there's a little truss right underneath the other red circle in the northwest corner of 10. So that is the pad configuration. That's the well configuration. When will this happen? To say the XRLs are fully permitted, they are on the drilling schedule. I believe that's next up. We have a rig Township South, and they'll be doing up to this location in early January. The 10 MRO wells, including the wellbore spacing unit, if we get those permits approved timely, we'll just move the rig over and get them wells up there. If there's some delay, we do have another drilling unit in the same township we can go to as an interim location and come back up and get those, but I fully expect that by the end of second quarter 2017, we'll have all the XRLs and MRLs drilled in this unit. We will be under control for that. We'll have production starting up in Q2, Q3, and being allocated to everybody, and that's the update. I think it fulfills the goal we outlined. We're happy with this process. It's given us the flexibility to work out here and do what's the appropriate well. If there are no questions, I am done.
Quick question. Please. Great presentation. Thank you, Commissioner Benson.
Yeah, did you say that you started out with 12 pads and down to 7?
We were authorized to go with 12. I don't know that we ever had
12 in the plan?
12 in the plans. That's okay.
All right. Thank you very much.
Those additional SRLs in the south, the southwest of 10 14, excuse me, you hit them from existing pad. Go there. Or there, yeah.
Probably, yeah, probably that actually had this down there, we can expand. There are some surface issues down there too with agricultural operations, which is one of the reasons we kind of put those on the back burner. The surface owner, Mr. Lewis, already has 4 pads out there, he doesn't want another one.
Clear enough that I understood. Thank you. Other commissioner questions? Thank you.
Sorry.
Oh, sorry.
Tell me about when I look at this thing just real quickly, the west half of 14 looks like not much is planned for that. Is that potentially a concern, or there's some future plan to put some additional wells in there? Because then you do create an issue that the minerals aren't developed on an equal basis, I guess, when I look at that.
Well, that's the nice thing about the URU, that everybody in the entire URU is sharing across the entire unit. So no, it doesn't create an issue out there, which is why you see no protests to this. And we have people happy that we're going out and drilling XRLs and MRLs, which are the most economical.
I get that, but if I'm the mineral owner in 11, and I don't see anything being developed in the west half of 14, then those mineral owners in 14 are getting a ride on me.
And they had a perfect opportunity to protest, which they didn't do. The appropriate number of wells does not say you must drill every possible well. That's what the order provides. There's no requirement to go drill these SRL wells if we believe them to be not appropriate.
I understand that, but I'm still concerned about how do we develop the minerals there in the west half of 14? Is it determined that there are no minerals to be developed there, or what?
No, obviously there will be some minerals there. If we ever get commodity prices back to $110 a barrel, then we will be working on that and doing those SRL wells. Right now, you're not finding any SRLs being drilled anywhere in the mix.
Right, so it's just the fact that the 1 mile laterals are not economic.
That's correct.
Okay.
No, thank you. Commissioner Benson. I don't want to make the same mistake twice. Are there other commissioner questions? If not, I'll say thank you. I can see Mr. Benson.
Thank you.
Mr. Benson, if you stay and we have Ms. Jost joining, we have Renewable Energy for a similar annual review. Welcome, Ms. Jost. Take your time to settle.
All right, good morning.
Nancy, whenever you're.
Thank you. Jill Demansky, Hearing Officer. Our second unconventional resource unit review today is Noble Energy. Noble will be presenting on 3,200 acre unconventional resource units. Noble has presented many times on these units. These units were established in 2013 and 2014. Noble will be presenting on spacing order numbers 535-302, 535-451, and 535-480, as well as cooling orders 535-434 and 535-635. A copy of the PowerPoint presentation has been provided to you in your portfolio, as well as a hard copy before you. On behalf of Noble Energy. Good morning.
One of the many signs it's December and the holiday season is upon us. It's time for the annual.
It is.
I'm sure Ms. Jones took note that the Barrett Corporation did theirs in 13 minutes.
I can do mine in about 5 if you like.
Time is yours, welcome.
Great, thank you. Good morning, everyone. Jamie Joes from Joes Energy Law here on behalf of Noble Energy. What I have for you is a summary of our COGCC orders on page 1. I'm not going to walk you through each of those because I'd like to just go ahead and direct you to page 2, which is what we're here today for. We are here to present the annual report on 3,200 acre URUs. As Mr. Yancey said, thank you very much for setting that up. We have 5 orders we're actually presenting on. The additional order that is not listed on here is pooling order 535-635, which pulled the green URU up here on the screen. So I'm going to start with order number 535-302 and the corresponding pooling order 535-435. This was a 3,200 acre unconventional resource unit that was approved by this commission in March 25th, 2016 for the Codell and Niobrara formations. Just by way of background, there were vertical and directional wells located on these lands, and those were specifically excluded from the URU. There were 6 existing horizontal wells within the URU lands, and those were actually brought into the URU within 1 month after the date of the order. The URU allowed for the appropriate number of wells to efficiently and economically and effectively drain the reservoir. In URU, order number 535-302, there were 58 new horizontal wells drilled in July of 2013, completed in October of 2013, and production started in November of 2013. So this was a very quick turnaround for Noble to come in and do the development of these unconventional resource unit. One item to note is that a unit agreement and a unit operating agreement were sent to the working interest owners and unleased interest owners for each of the URUs we're discussing today prior to the hearing. I think that is a critical factor in the review and the determination of a URU because they're in the UA and the UOA, unit operating agreement. There is a determination of operatorship, in this case Noble, that is presented to each of the parties in there. So that is, I think, one of the benefits of the URU that you've seen from Noble's perspective, is that that request for operatorship is put out there early and is reviewed by all parties. Noble was designated the operator under the unit agreement and unit operating agreement, and each of the URUs we will talk about today does utilize centralized facilities, which are shown on this location map. The facilities are in the purple squares and the well pads are in the black squares. So you can see how this has been laid out and development has been planned to minimize surface disturbance on these areas.
Mr. Chairman, may I interrupt for this? Ms. Jones, I apologize. I haven't been around for most of these URU matters. The 6 existing horizontal wells,
yes,
they are still in operation?
I believe each of them are still operating and they are producing on the 3,800 acre basis now because they were brought into the URUs.
They were?
Yes, yes.
Thank you.
Yeah, you're welcome.
Thank you.
3,200. My numbers are off this morning. So with that, I will go ahead and move to our second annual update, which is for order 535-451. This URU was approved on December 16th, 2013, again for the Codell and Niobrara formations, and we have the same instances that occurred with respect to the exclusion of vertical and directional wells, but the inclusion of 3 existing horizontal wells when the URU was approved. This URU did have federal minerals in it, and so we worked very closely with the Bureau of Land Management who did support this URU and the reduced setbacks for 300-foot setbacks. I will say that any federal well in this URU was excluded for purposes of ensuring that we maintain the BLM's mandate to have separate communitization agreements for purposes of federal wells. Noble drilled 41 new horizontal wells in this URU. Drilling began in October of 2014. Completions began in January of 2015, and production began in March of 2015. So again, a fairly short 10-month turnaround with the development of this URU based upon the approval of the URU from the state and the initiation of development. In the same instance as we had with the other one, a unit agreement and unit operating agreement were sent out to all working interest and lease and interest owners. They had the opportunity to review, and many approved this agreement because at the time of the approval, Noble had a 92.8% leasehold and no protest to this URU. Again, Noble has utilized centralized production facilities shown in the purple squares. And this URU actually asked for up to 16 well pads, just for purposes of development, but they have only utilized 7. So again, a benefit of these large-scale development plans with respect to unconventional resource units does result in minimization of surface impact. For our last URU, this is order number 535-480. That was pooled by order 535-635. This URU was approved in April 28th, 2014. Again, for the Codell and Niobrara formations, the vertical and directional wells were excluded. The horizontal wells, 5 of them, were brought into the unit. Again, we did have federal minerals in here, so Noble did work very closely with the BLM. BLM supported the unconventional resource unit and the 300-foot setbacks. And these were reciprocal setbacks, I would say, for the southern boundary of section 35 and then the eastern boundary of section 25. Since then, I believe that Noble has come in and has obtained the actual reciprocal setbacks of 300 feet from those adjoining sections. Here, there's 38 new wells that were drilled within the URU. The drilling's operations started in April of 2015, completion started in July of 2015, and production started in August of 2015. At the point in time where this URU was approved, Noble had a 91.8% leasehold in here, and had also submitted the unit agreements and unit operating agreements to each of their partners. So really with this, to wrap up, again, utilizing centralized production facilities, there's approximately 10 well pads within this location. Some of them were existing well pads from the initial wells. I will say from the URU perspective, the pipeline infrastructure has been utilized, and the gas is taken to one of Noble's plants, depending on where it's located, and the oil eventually is transported by basically interstate transmission pipeline to Cushing, Oklahoma. So with that, Noble's plan development of each of the URUs was presented during each commission hearing through each of our annual reports. Noble has carried through with the plan development that was approved by this commission. With this, we would respectfully request that the commission treat this as a final annual report for each of these URUs. At the present time, these URUs are fully developed, and Noble is focusing its efforts elsewhere in the DJ Basin. With that, I thank you for your time and welcome any questions.
Thank you, Ms. Just. I have, well, Commissioner Benton mentioned I had, but I'm going to have one for you, Mr. Tracy.
I'll defer to you.
Thanks. I thought the request that Ms. just presented us with this today being the final URU presentation on these 3, how would staff feel about that?
Well, as long as the unconventional resource units are fully developed, we are fine with the request to make this the last review. I would anticipate that if Noble did come back and decide to do anything additional within this unit, we would ask that they re-present on an annual basis. But that my understanding is that's not within Noble's plans at this time, so we would be in agreement with making this their last annual review.
Thank you. Commissioner Benton, please.
Sounds great. Thank you, Mr. Ansey. So I noticed in particular this unit, and the other one, I noticed there are a number of 1 mile laterals in this unit. So is it safe to say that Noble determined that those wells, those 1 mile laterals were economic?
I will say from my perspective, they have developed those out on the 1 mile plans. And that is how these were planned for and presented to the commission for purposes of development of these URUs.
If I could redo it today, they would not be short.
They would be long ones.
They would be long, however, determination of being economic or not depends on the area of the basin. How much gas, how much oil. We're lucky that this is very oily up here, which helps the economics on normal length laterals. I'm Sean Howley from Noble Energy Development Planning Team Lead.
Sean, thank you. I appreciate that clarification. Because it goes back to the previous unit in which there was a section with some 1 mile laterals that were not developed. It leaves me some concern because I think that one of the things that I believe this commission has heard, that it makes a lot of sense to develop these areas sort of continuously so that you don't end up with some reservoir pressure loss and potential depletion effects and so on. So I guess the question to me, Mr. Anstey, would be, I'd like to see a follow-up from Bill Barrett as to the economics on the undeveloped section as to why they don't think that that works.
Certainly, I will put that in my notes and I'll ensure that they present on that.
It needs to be a little bit more support for why those minerals aren't being developed concurrently with the rest, because I'm concerned about reservoir pressure depletion in that area.
Thank you very much.
Thank you.
Mr. Chairman, may I? Please. In the nature of a comment rather than a question, as I said, I wasn't around on the commission for most of this, but it appears to me to be an instance of the commission approving something that really works. We occasionally would do that. We spend a lot of time fussing with, you know, and this, I appreciate this, Ms. Jost, it has a very positive feeling. Thank you.
Thank you, Commissioner Pierce. Director? No?
The ones you're being presented today have worked wonderfully.
Great reports to have. Commissioners, if I may, how do you all feel about the request by Noble Energy that if there's no additional development in these URUs, we don't?
I would make that motion, Mr. Chairman, that this be the final report.
We have a motion and a second. Discussion?
Call the question.
Motion and a second on the table. All in favor, please say aye.
Aye.
Aye. Opposed, nay. Hearing none, the ayes have it. Thank you, Ms. Duransky. Thank you, Ms. Jost, and folks from Noble Energy. Director?
Mr. Chairman, I apologize. I do not have the order in front of me that approved the URUs, and therefore cannot speak to the language of the annual report requirement. Certainly, you commissioners have the authority to amend that order. I may need advice from council as to procedurally what needs to happen to amend that order. Like,
Can we get advice from council that if we just amended that order?
Yes, you may.
I think we just did.
Yeah, I thought we just did.
Well, the question would be notice, right? So the order says, this matter shall be set for review by the commission in 1 year and annually thereafter without exception being granted by the commission. So I think you want an exception, and one thing I think it would be appropriate for Noble to request a variance that the director signs off on if you're worried about, did we just create an exception or not? I don't think we amended the order because there was no notice other than this just generally being an update. So I think the variance procedure would accomplish what is intended by virtue of that language.
So you're saying subsequently Noble should ask for a variance that
From the director.
based on the commission's clear direction I would have no trouble deciding.
I think that's what you take care of.
We would be happy to submit that variance request. Thank you.
What will we do next December?
I am sure you will have
Somebody
something
find
else.
something to
You'll hear from Schwinn and BBC.
We'd like equally encouraging reports from them. Can I say something? No, of course.
Thank you, everyone.
Very good, thank you, Mr. Yancey. Mr. Yancey, I think you have our next matter as well.
Yep.
Number 161200544. Dennis Blackwood Energy Inc. The attorneys get settled. Parties.
Mayor, make a comment. A couple of our staff members had initially been in the state and there was communication, they're not here. I'm hoping that they'll call in at some point in time during this hearing, so if somebody could send, it's two of our staff members participating. I would in their absence, Ms. Ash will be here. So, and Ms. Burke, sorry.
So we okay to proceed from staff side?
Yes, we are okay to proceed.
Understood, so we may have folks dialing in.
Yes.
If not, we're still okay to go.
Yes.
If the applicant is okay with that?
Yes.
I'm Jill Durante, hearing officer. We're here on docket number 1612-00544 in the Adena Field, Morgan County. This matter comes before the commission on an application of Black Raven Energy Incorporated for variance from order number 1-186 to modify the order to require Black Raven to perform a mechanical integrity test on 21 wells within the Adena Field on or before December 31st, 2016, and waive the requirement to return to active status or plug and abandon 20 wells within the Adena Field. Order number 1-186 was entered in March 2014. Staff recommends approval of this application. If there are any additional questions or any questions for the staff, Margaret Ash, our Field Inspection Unit Manager, as well as Diana Byrne, our Eastern Region Engineering Supervisor, are available for your questions. Now, on behalf of Black Raven.
Thank you, Mr. NC. My name is James Parrott. I'm with Beatty and Wozniak PC. I'm representing Black Raven today. And I'm going to let my witness introduce himself.
Thank you, Mr. Parrott.
I'm David Kunovic. I'm Executive Vice President for Black Raven Energy. Actually, for Interject Resources, Black Raven Energy is a wholly owned subsidiary.
Mr. Mayor, do you need to swear Mr. Kunovic?
Yeah, so would you please raise your right hand? Do you intend to present testimony? Mr. Parrott, do you intend to?
I think he's just here to answer any questions from the
Okay.
commission, so you consider
Yeah,
that
wait,
question.
raise your right hand and or affirm under penalty of perjury that the testimony you will provide today is truthful and accurate.
Yes, I do.
Thank you, sir.
Thank you. Very good. Mr. Parrott, I believe the floor is yours. Right, Mr. Renzi?
Yes, that's
After the
correct.
presentation? Very good.
Yes, that's correct.
Now you're ready.
So I think first thing that's in order is just a quick summary of what we're asking for today. So if the commission is not already familiar with it, then I hope that this update will be helpful, summary will be helpful. If you are, I apologize for boring you. Essentially, there's over 100 wells in this field. Black Raven bought it, has been a steward of this field for some time, has been actively managing it and taking care of it with the somewhat unexpected, I think very unexpected for almost everybody in the industry, crash in prices a couple years ago. The pace of that stewardship and updating the field has slowed down somewhat, and we are asking for the commission's forbearance in allowing us to proceed on a pace of managing the field that is economic. I guess I'm somewhat reminded of, I think it was Amarillo Slim's proverb that you can shear a sheep many times, but skin them only once. We are actively involved in this field, or rather Black Raven is actively involved in this field, and hopefully the recent oil price increase in the past couple of weeks is reflective of a longer term trend, but we're confident that we're going to be able to come back in 2017 and comply more fully with the obligations set out in order 1-186.
Meanwhile, we're asking for a variance from that order for the calendar year 2016. Thank you.
Thank you, Mr. Barrett. Mr. Nancy, anything staff would add?
No, I will indicate that our staff has worked closely with these issues, and this was something that I also had the ability and opportunity to sit in and talk to the parties about, and our staff is in agreement, and we do agree that at this point, this would be the best course of action for all of the parties involved. So we're in agreement with, and we recommend approval of this application.
Thank you. Director, Ms. Murphy, something to add?
Yes, sir. I just wanted to check to see if Future is on the line.
I think someone heard it. Sounded like somebody tried to dial in.
We were diving in to set it up just in case he.
Oh, okay.
But we have other, his supervisor available for any questions, or if there's any additional information the commissioners would like.
Let's go right there. Thank you, Mr. Commissioner. Questions? Commissioner Raver.
Yeah, can the COGCC staff confirm that housekeeping is sufficient at the wells? You want to do that?
Morning, Margaret Ash, Field Inspection Manager for the Oil and Gas Commission. We can confirm that Black Raven does a good job on housekeeping, and they actually generally do more work than what they're even required to do. They made a lot of good progress cleaning up this field, and I think it was like the attorney said, commodity prices slowed them down, but before that it was really, really amazing progress. And we're very supportive of this variance.
Thank you. Thank you for the question, Commissioner. Somebody joined?
Hello?
Yes, Kim Shore.
Thank you, Kim. We hear you. Thank you.
Thank you.
Commissioners, other questions of staff or the applicant?
I have a question.
Please, Commissioner Hawkins.
I see that you're asking for a waive the requirement to bring those wells back or plug and abandon. Can you tell us what do you have a plan for the wells at this point, or?
Well, yes, we do. It is one of our company's biggest assets, and we've spent most of this past year building a geologic model that's very sophisticated, a way to look at the remaining reserves in the field that has never been done before. And we have been working diligently to recapitalize the company. I'm one of the 4 officers in the company, and I can't say hardly anything more, but we've made really good progress. And I expect during 2017, we'll be able to get back on track and fulfill our obligation.
Are there other wells that would require MIT testing besides these?
Yeah, we're on a schedule to either restore production, convert to injection, or P&A, 20 wells per year. And we are also on a schedule to MIT wells that are currently shut in. There are 111 wells that are currently shut in or temporarily abandoned. And many of those are already on an MIT schedule. And what we're working with the commission or the staff is to get more and more of those wells on an MIT schedule.
Approximately how much does it cost to do an MIT on another well?
Big range. If it's a well that already has some sort of a packer in it, like a well that's already been MIT, it's a matter of loading the the casing with water and bringing out a pressure truck, pressuring up, seeing if the pressure holds. Those wells that's probably a $500 bill. Wells that don't have packers, we have to get a rig out there. We have, sometimes we can set a wireline packer to get an MIT. Those bills range from $5,000 to $10,000. And then MIT wells that require a more substantial effort can be 20,000, 15 to 20.
Out of the 111 that are temporarily P&A or abandoned, do they all need MITs?
I'll let James answer that question.
So the MIT requirement is set forth elsewhere in the commission's rules. It's not over 1-186. So in a sense, we're asking for variance from both the prior order and the rules. And that's sort of a sliding scale. You have 2 years after initial shut-in and then 5 years every thereafter. 5 years thereafter, every 5 years, you've got to do your MIT test. And 41 wells came up on that schedule for 2016. And 21 of those wells were MIT. There are another 20 that are on the schedule for 2016 under the commission's rules. And we're asking for a variance to not have to MIT those 20 wells.
And over, eventually they'll get MIT, is that correct?
Absolutely.
Okay, so it's just the list that's in the table where you have the list on MIT where it says none. Those are sort of your priority ones to get an MIT test conducted.
Oh, I'm sorry.
It's in your exhibit, there's a great schedule there that is the last and when the next ones are planned, but there's several in there that say none.
Those are the wells that we haven't got to yet, and the idea was to, over a period of time, that was the original order, get those all taken care of. Either restored to production, and we don't bring a well back on, we don't bring an injection well back on, or a newly producing well back on, or any of those things without MIT first. So first thing we do when we go out to restore production is get an MIT. Then in addition to that, we're working through this list of wells MIT. When we bought the field, it hadn't been done for a while, so we kind of took it over and we're trying to get caught up.
Yes, I think Rex Concrete had this deal originally, I believe.
Rex, and I think we're the 5th operator, and I honestly believe that our company has done more to this field in the short period of time we've owned it than the previous 5 operators combined.
And just to comment, this is a large field with a lot of resource potential. So anything that can be done here, I guess this goes under what Mr. Pierce said earlier about doing a good thing. Anything that we can do as a commission here to give them the opportunity to get after this resource, I fully support.
Thank you, Commissioner. Commissioner's final comments, or what's the pleasure of the commission?
Mr. Chairman, if I may, please. First of all, I want to express appreciation to the operator for working with staff and to the staff for working with the operator to try to address these stress issues, if you will. And I would like to move that the commission approve the recommendation.
Second.
Thank you. We have a motion and a second. Discussion? Hearing none, we'll call the question. All in favor, please say aye. Aye. Opposed? Nay. Hearing none, the ayes have it. The motion is approved. Thank you to the applicant, staff, and it was very helpful to me, staff, to hear the enthusiastic recommendation. It was meaningful to the operator. Thank you. We'll look forward to hearing the results of your further development and compliance next year.
If I may?
Please.
I also would like to thank the staff. They've been very supportive, and thank you, commissioners.
Well, thank you very much.
Thank you very much, commissioners.
Thank you. Thank you. Thank you.
Thank you very much, guys.
Commissioners.
I'm gonna hang up, okay?
It's 12 o'clock.
I wonder if we might have our executive session over lunch, but not require the full hour to do so. And perhaps if a motion is made to go into executive session, we see if we can do our business in half an hour and then reconvene for the two staff presentations.
I will make that motion.
Second.
We need a, Mr. Matter, the language, if we go in, the motion to go into executive session needs to discuss what we're doing, correct?
Sure. Pursuant to the Open Meetings Act, Colorado Revised Statute, Section 1464023A2 enables the commission to go into executive session for conferences with an attorney representing the board to discuss disputes that are subject to pending or threatened litigation. One identified on the agenda is the neighbors affected by Triple Creek versus the Commission, 2016 CV 34274, which is pending in Denver District Court. And the purpose of the executive session was to give a general status update, background, and to receive legal advice concerning the claims and defenses in that lawsuit. So with that, we can move to executive session on proper motion.
A motion and a second on the table to move it on the, do it again now that subsequent to that explanation. Who made that? Mr. Pierce? Mr. Holmes? Does anybody want to renew that motion? Mr. Benton?
Yes.
Yes. And the seconder?
Yep.
Thank you. Discussion. All in favor, please say aye.
Aye.
Opposed, nay. Ayes have it. We'll move into executive session. Thanks everybody for your patience. Those from COGCC staff and those interested in discussion will come back at 12:30 for the remaining two agenda items. The broadcast will be shut down. The tape will remain spinning for compliance purposes, and we will reopen the webcast at 12:30. We're going into executive session. Thank you.
Mr. Chairman, if I may, I'll.
We need to just do a little housekeeping on executive session.
Absolutely, thank you.
Thanks, Rick. Okay, thank you. We are back. It's the December 12th, 2016 meeting and hearings of the Colorado Oil and Gas Conservation Commission. We just completed a brief executive session with our attorney. Some legal advice and status update regarding claims, defenses of issues and at issue in neighborhoods affected by COGCC. Commissioners, we need a motion to exit executive session, please.
So moved.
Thank you. Can I get a motion and a second discussion? Hearing none, all in favor, please say aye. Aye. Opposed, nay. Let's have it. We are out of executive session. We're back in public session. And let's turn it over to Director LaPorte, please, for staff presentation from the Northeastern Field Inspection.
May I make one quick comment? We did so pursuant to the open meetings law, 24-6-402-3A CRS, which enables the commission to enter into executive session to discuss pending litigation.
No, Assistant Attorney General matter, thank you. Now, Director.
Thank you, Mr. Chairman. It is my pleasure to introduce to the commission two of our Northeast Field Inspection Unit inspectors, Jeff Rickard and Craig Carlisle. Jeff and Craig and Jim Driecuff, their supervisor, gave an earlier version of this presentation to the management team and perhaps a broader audience of staff probably 7 or 8 months ago. And it was informative and entertaining, and we thought it would be of value to the commission to hear from these gentlemen who are on the ground every day in the heart of the Wattenberg, where the vast majority of the activity is taking place today. So with that, let me turn it over to Craig.
Okay, thank you. It's a pleasure to be with you today.
Just introduce yourself into the microphone.
My name is Craig Carlisle.
And I'm Jeff Rickard.
As Matt said, we're in the Northeastern Field Inspection Unit, which is Wells County. Jeff and I started about the same time, 3 years ago. In that time, we've driven 180,000 miles on the back roads and byways of Wells County, and conducted over 12,000 field inspections, consisting of everything from pre-construction through plugging and abandonment. During that time, we try to pay attention a little bit and try to learn about what the industry is going through. So what we have is a presentation of what we observe on the ground, and thought that might be something to be of interest to your group. We also really appreciate the idea of being in a building with electricity and running water. It's a big improvement over our normal farm. Jeff's we have 3 points to our presentation. First, Jeff will talk about drilling technology and velocity, how fast these wells are being drilled today, and some of the technology that enables that. That we're seeing in the field. Then I'll talk a little bit about 2 wells just out of interest that are separated by 300 feet and 10 years. So what was a decade ago in the same reservoir, same geographic facility area, what happened 10 years ago versus what we have a well that just had come online with 3 months of production. So we'll review that. And then talk a little bit about some of the advanced gathering systems and their conservation potential. So anyway, with that, I'll go ahead and turn it over to Jeff. Oh, one other thing. If you like anything, you can tell Matt. If you don't like anything, tell Dave.
So what I'm going to go over real quick, go through is how a well is currently drilled in Weld County, some of the current technology. And a quick disclaimer about what's currently, the word current. When I explain some of this to people who may be drilling onshore up in Wyoming, this stuff will be Star Wars, newest, latest, greatest stuff. Some of the things I'll mention that are new here, you might say, well, I was doing that 30 years ago offshore. So this is just currently what's going on to drill a well up here in the TJ. So what we've seen is rig specialization. They'll have a series of rigs come in, and I'll go through that. We saw the switch probably about 8 years ago from kind of your trichomes and your older things to the PVC bits. About 3 years ago, I think was the last time I saw water-based mud outside of surface casing. So pretty much everything now is petroleum-based mud, invert mud, oil-based mud, your term of preference, with a few exceptions of some of the new polymer muds they're trying closer to cities to cut down on odors. And then we'll talk about how fast they drill these wells. So as you know, after the location's construction, the first thing that'll come in to set conductor casing is one of these auger rigs. It's just a modified excavator with just an auger on it. This sets the conductor casing. I cannot remember the last time I haven't seen a casing that was 2 joints, so 80 feet deep. And they'll do 5 to 8 of these wells, conductor sets in a day. It's really quick. That picture was taken in a yard because it's rare to see one out there. That's how quick these conductors are set. So I had to go find one in the yard. I couldn't find one in the field. Something we saw, then it disappeared, and now it's coming back, are what we're calling these sputter rigs. And before they bring in the big long string rig, this will drill surface casing. It's cheaper to run per hour. You don't have to jet out the water-based mud when you're turning over. So this will drill the surface casing. It's actually on a hydraulic tower, so they can put weight on it when they don't have a lot. And this will take a full BHA with directional tools and everything. We're commonly seeing the surface casings go down to 1,800 feet. And in that 1,800 feet, they're actually kicking off. So we're seeing the directional, pre-curve start at surface casing. They are.
You lost me on BHA.
The end of the bit. So that'll be the bit, the mud motor, your heavy collars,
Bottom hole.
bottom wall assembly.
Thank you. Question. Are they drilling with casing and then also doing directionally, or is that just, you said rotating casing, which implies that they're essentially drilling with casing?
No, they're drilling with the drill string coming in with casing next surface.
Has anybody tried that?
Not that I know of. Yeah.
Because that's, we've looked into that in some places. Usually not with surface because it's pretty good size, so it's, both constituents, but generally you're looking at drilling with 4.5 or 5.5 casing in some cases. So you just drill your casing out and then just cement it in place.
Yeah, I haven't seen that commonly. They might be doing it. We saw these a lot 2 years ago, then they disappeared, and now they're coming back. And why that is one of these surface sputter rigs can support 6 big rigs. That's how quickly these things will go. They can almost do 1 hole a day. Just some more 1,800 feet, typical. Yeah, done in 8 hours. Then the Big Daddy comes in. These rigs, this is precision. They come in, and these things are set up in a day. They're all skid mounted. All the houses, all the skid offs, they all plug in together. It's rare now on these rigs to see someone handling pipe. All the pipe is done automatically. It's called an iron roughneck, an iron derrick hand. You really won't see a lot of roughnecks throwing tongs around and everything. It's done automatically for safety, and it's quick. And they're running top drives now, so I haven't seen a Kelly in years.
That's a huge change.
Yeah, and what that does is you're running stands now, so you're only making connections every 90 feet instead of every 30 feet.
Also, you can rotate up and down,
Yep.
which you can't do with Kelly system. So that really, people haven't talked about top drives that much, but that's made a material difference.
Absolutely. A huge thing we saw is the mud pump horsepower. They're running 1,500 horsepower on their mud pumps, and we've been told 200 horsepower mud pumps are coming soon. 2,000, sorry. Order of magnitude here, no difference. So this is a PDC bit, and what that 1,500 horsepower means is one of the nozzles on the bit's about the size of a dime or a quarter. If you can imagine, 2 old muscle cars, 400cc engines revving at full max, that amount of horsepower is running through something the size of a dime, 600 gallons a minute. That's how much energy is funneled at that bit.
So for the attorneys.
Fish food.
That's a big deal. What he's talking about is that's horsepower at the bit, which helps with hole cleaning, increases your velocity. Essentially, you're cutting velocity. To go from 1,500 to 2,000 horsepower is probably going to be a material change in
how fast they're gonna get these wells down. The more horsepower you put in the bit, faster you go.
It is the analogy of a car going down Benjamin Speed, funneled into the size of the dial.
It's the 400 horse versus the 1,000 horse tracks.
Yeah. These bits will last the entire well now. They've got them down. They kind of know the formation. They know how many cutters they want on them. They know what shape they want them. They know what weight they want on them. And they know how fast they want to turn. And those bits are rented by the foot. So they don't own the bits anymore. If you didn't know, PDC.
It's not PDC.
Petroleum-based mud is pretty much now the normal. There's a term they use for the hole it creates. It's called gun barrel clean. You get very reduced sloughing, which actually helps because you're only using about a 5% overage on your cement instead of about 20. Your friction reduction, that means is you're getting more horsepower to the mud motor in the bit. Think of this as if you get a glass of water in a straw, you can suck it up pretty easy. Now get a Wendy's Frosty and try to suck that up through a straw. The viscosity of the petroleum-based mud is different. And so you reduce that friction, and you get it down, you get your horsepower to the bit. The petroleum-based mud is rented. It's not owned. So they'll rent it, they will pay for what they lose, and they will give it back, and it will be recycled and used at another location. We'll talk about this next point here. The newest things I've seen, and we've seen in DJ Basin in the last 6 months, are we're running agitators on the drill string now. Now what an agitator is it's a tool. It's run about 2,000 to 3,000 feet back on the drill string away from the bit. It's a solid screen and a rotating screen. Every now and then those screens will lock up to block the flow of mud. So you get a hydraulic hammer, and that's happening constantly. So it's and what that's doing is when they're sliding, it's taking that drill string from a static friction to a kinetic friction. So you're lowering friction on the drill string as you're drilling. When you're sliding, you're building curve. You're not rotating the drill string. So when you're not rotating that drill string, like I said, you can get that static friction. Kinetic friction is always less than static friction. So if you're moving that drill string, you have better control of your bit. Air-filled casing. So this is new. When they're done with the hole and they're going to run the casing in, they run a rupture disc back through the lateral part and float the casing in. This means less horsepower to have to push that casing in and less friction along. And then when they're getting ready to cement, they'll pump. It'll break that rupture disc in the casing, and then obviously cement will come out the float collar. It also helps with centralization. If you have less friction moving that casing string into the hole, they're using the plastic or polymer centralizers, so not the metal ones, so those can wear down. So if you don't have as much friction running that casing in, you get a better centralization. And then one of the other newest things we've been seeing is their cuttings management disposable. Before you take your cuttings and just haul them off site. Well, with the petroleum-based mud, that creates manifest issues and toxic things. So what happens is it comes off the shell shaker, runs off a trough, it goes into a mill basically, and they get pulverized into a powder. That powder moves into a centrifuge. The centrifuges turn, they're dry, they can recover that mud, and then what's left they can compress into a solid and just take to a landfill. So they don't have to manifest it to just dispose of it anymore. Drilling rates. These are just kind of some basic numbers. If you take an old vertical well, you say it took about 7 days to drill, and I just used 100 feet as a round number between the Niobrara and Codell. I know that's high. If you want to think about that in days to drill that well, you've got about 14 feet of pay a day. A modern horizontal, you drill 5,000 feet. You can do 10,000 feet, so a 2-section lateral in about 4 days now. We did this presentation, we're doing 5,000 feet. But if you think 5,000 feet in 4 days, your payoff is 1,250 feet in the pay zone per day. That's a 90 times more efficient operation than it was 20 years ago. And that is, I will turn it over to Craig.
What was your goal? Did you say it was 100 feet in how many days? 14 days?
I said 7 days.
7 days.
You don't know how nervous I've been over lunchtime with the swearing in and telling the truth thing. There's lies in my slides. And so I was really sweating it, but anyway, we'll go ahead and I'll lie a little bit, but I'll tell you where I'm lying. So hopefully that makes things. This first slide I've got is really just to show how beautiful Colorado is and how lucky we are to live here. This is the St. Vrain River going along here, and then this is a site I'm going to talk about where they have 2 drilling pads, 2 drilling locations going concurrently. It's called the Top Gun site, and it's just south. This is the St. Vrain power station. So anytime you drive north on I-25, you see that big white plume of steam. We're just to the south and west of that for the wells I'm going to be talking about. So my first lie, I did the slide 300 feet and 10 years apart. And then I realized, well, the wells are actually 13 years apart. And I thought, well, nobody cares, but maybe they care. I don't know if I care or not. I don't want to change the slide. So here it is. All right, let's go back to that a little bit. So this, just to give you some orientation of where we're at, Platteville increased the traffic light intensity by 50% this year. They've now got 3 lights. So you go to the second light on Highway 85 and you turn left, you go out here a mile, go a half mile north, over 2 miles. And this is a lot of what we do every day. This go a mile, turn left, turn right. So anyway, I'm ended up over here at County Road 34 and 19. And this, you can tell something's going on here. That's the section I'm going to be talking about a little bit. And that's the St. Vrain Power Station, which is the most notable landmark. So you can see we're about a mile south and west of that. The 2 wells that I'm going to talk about are 2 of them. The Mayor 415 was an old vertical well. You can see there's 2 wells here, and then this is its original pad. There's 3 tanks there. I've got a picture of later. And then in this location, they come in and done a massive development where they've had 6 simultaneous drilling sites and have put in 30 new wells. But I'm basically lazy and I'm not going to add 30 things up. So I did 1, and that's the Viper Pyro. And it's located in this line of wells here. But my point being that these are essentially geographically in the same area, they're producing from the same reservoir, but they're separated by 10 years of technological development. So I just kind of want to see what that meant. So that's about. This is a close-up of the 160 divided by 4 is what, 8th section. Okay, so 40 acres. Did I do that right? Yeah. So you can see the new wells here, and then the old ones. This 8th section had 5 original established vertical wells. It's owned by the producing company. The surface rights here, which we just love when they do that, saves us a lot of issues. So it had 5. They put in 30 new ones, 6 simultaneous drilling pads, which gets pretty active when you're hauling dirt in to build the pads and that sort of thing. A lot of truck traffic in the development of that. There's 2 production batteries associated with the new wells, and on those 2 sites, there's 4 LAC units. The LAC being the least automated custody transfer. So that's where it's sold, and then the product now is going into a pipeline. We'll talk about that in a little bit more detail as well. Oh, this is kind of interesting. Yeah, it's embarrassing, but I drove around out here inspecting the Goose Viper Maverick for 18 months. I didn't know it was Top Gun. It takes a little while to catch on when you don't get it. They like to name their pads, their development after movies. So there's a Batman with the Joker and that kind of. But I'm going to pick up on the next one, I swear. With Google, you ought to be able to figure that out. Okay, the 2 wells. So somewhat random. What I mean by that, obviously, I picked 2 right next to each other, so it's not random. I didn't know any other word. I didn't go get the best well and the worst well. I just kind of took two that were in line there, you know, not trying to make a point or anything, but just, it's a random study, a discussion of what's going on over that period. This is the old well. There's a lot of technology in this sign. I don't know if you can see that, but the well name is behind the pipe. And the producer can do that 99% of the time. You have to get out of the truck, go over and lean over to see this, what the sign says. So anyway, I appreciate their consistency in that. Kind of. It was drilled in 2003. My new well was 2015. That's one of the lies I've been, that's 12 years, it's not 10.
You're not under oath.
Yeah, I wouldn't be here. I would have fainted a long time ago. So the old well, my major point in this doesn't have a fence. It will ultimately, I suspect. You really wouldn't tell the difference driving by on a county road. They're essentially the same. This is in a line of 4 or 5 of them. This one was in 2. Other than that, driving by on the County Road 19, you wouldn't notice anything different in those 2 wells. The battery, you know, we've got thousands of these kind of setups. There's 3 tanks, the produced water tank, and a separator, and the emission control burner. More about that later. And then a gas meter run. Not as good a picture of the new battery because you can't get far enough away from them to get a picture. That's a pretty big installation. So what I focused on here was the black unit. It's just a little box, and it does the magic of turning the oil into money right now, which is what we all like to do. So I'll have more on that as well. So the Mayor well, 415. This is what they did. This is the production, the perf zone. So this is what it's all about. We don't drill down almost to the pay zone and stop because that's not near as much fun. It's more making money out of the thing. So what this particular well had is 66 feet of perf zone in the Niobrara and then 12 feet in the Codell. So that's what they used to do. The Viper Pyro is like a 2-section. Everybody was calling them something different today. I've never heard that.
XRL reach.
Extended reach. In my experience, everybody calls them sections. So 1 section, 2 section, 3 section well. Kind of interesting.
Well, I was an attorney that was using that.
Yeah. So this is like a 2-section well. So it's down about the same depth. It's in the Niobrara, and we've got 9,300 feet of pay zone now. So this slide here is to show you that 9,300 is bigger than so, you know, I think that's the major point there.
Lawyers too.
Yeah?
Yeah, lawyers got that one.
So that's kind of the significance of that. So when you look at the first 3 months, so it's not another lie coming up here. It's not the first 3 months because the first month you don't know it was a full month. So I have to go to the second month. So it's the second, third, and fourth month that I'm looking at to get some comparison between the 2 wells. The Mayor in its first 3 months of production produced 1,920 barrels of oil, 11,000 MCF of gas, which translates into 11 standard. An oil tanker usually holds about 180. That's a full-size truck. And so to remove that oil from the lease, then that was actually 11 trucks over the 3 months. Over here on the Viper Pyro, in its first 3 months of production, produced 41,231. Now, I probably should have had a chart to have this number be bigger than that number, but I'm just going to leave those as self-evident. 123,000 instead of 11,000, and 229 oil tankers to remove that same amount of oil. And in reality, what happened at that location was no oil tankers because of the advanced gathering system. So that's kind of a cool deal. That's that. Then I'm always interested in money. It's been a theme ever since I was on my paper route. When I was 13, God, that was a long time ago. So I went ahead and extended those numbers with dollars. You can see that the oil price is pretty stable over that period of time from 2003 to 2015. It was $44 there, $45 there. So that's kind of interesting. When you extend that out, the mayor produced $41,000. That's inflation corrected. $41,000 of revenue off of that, 1.8 million off the Viper Pyro in the same 3-month period. That's a ratio of 21. I said stable on the price of oil during that period. That was another one of those lies I kind of slipped in there. This was actually the price of oil when the Viper, or when the mayor was drilled, and this is the price of the Viper Pyro. This is one of the challenges of our industry. Every one of those green arrows is a legitimate linear progression of where the price of oil is going to go. It's real hard to have plans, investment, capital outlay based on, put those kind of estimates into your internal rate of return, and it doesn't work out so great. It's either going to be, over here it looked like oil was going to be some $1,000 a barrel, and over here it looks like we're going to give it away. So that's where we live in this industry.
The only thing that's more volatile than that is the price of natural gas.
So in my comparison, I had 1-to-1 because I had that lazy thing going. It's not really 1-to-1. The old well is still there. It's still capable of producing, but we put in 30 new wells. So the impact is now 1.8 million out of the well. Out of the project, we're up to a number that's close to $10 million in 80 acres per month. So it's pretty staggering. This is what it looks like. This is, okay, I'm sorry. I like SketchUp. It's a hobby of mine. Doing 3-dimensional drawings. Just couldn't resist to put one in the presentation here. This would be the well bore coming down. The long ones here are obviously the new 30 wells going, they run east-west here. And then you can see filtered in amongst them some of the little pay zones from the original 5. So that's just kind of the magnitude of what's taking place in the development of this reservoir. And that's actually a picture of the, oh no. This is what a space shot would look like of the pad here. They were color coded. Some of them still are. Something happens when you change computer files. I don't know what. But you can see the red pad then produces these wells, and the white pad, I don't know why it's white, green, yellow. So anyway, you get the idea. Now what's really cool about that, if you remember the picture I had from the start, this area over here to the west was in the St. Vrain River Valley. Well, to do this kind of production, we have 30 wells. If we were doing the old wells, that would have been 60 tanks down in the river basin. And now with the current gathering system, we have 0 tanks in the river basin. And we have, they have 1 tank actually that's, I don't know what that tank's for, overflow or something, but it's going in directly into the pipeline system. Dramatically less impact. So the gathering system that's on location now, we have the gathering, or the LACT unit, and then the horizontal heat treaters. I guess this is that. The LACT unit, and that's what's on the lease location now. That's all gathered under pressure, 400 PSI in the gathering systems. And it brings into play these little 5 things here, which are new because what used to be happen to the product that's produced in these, it's called the gravity distillation tower, is it produces not right, it captures F-butane and propane. Well, before, those were lost on the lease. Whenever you open the tank, it would boil off in the tank and disappear into the atmosphere, or it would be burned in a flare. So it's kind of cool to be turning what was a least loss before into a marketable product and reducing emissions at the same time. So pretty cool deal. It goes through that process, then it goes into temporary storage. This is on County Road 49. You guys are all oil people to some extent. I don't know if you've been over there, but I'd recommend a tour up and down County Road 49 to see the development between Kersey and Hudson. That represents, so there's 5 of these, and they're a quarter of a million barrels per tank. So that's 1 million barrels of oil. So even at $50, that's a lot. So from there, it goes into this, what's out there is White Cliff. I think there's another one under development, Sand. There's a couple more pipelines being developed. That pipeline carries the volume of a little less than what's produced in Weld County. It's transferred through that pipeline down to Cushing, Oklahoma. And if you like to worry about things like I do that you can't really control, I wish I could stop that. But that earthquake in Cushing, Oklahoma could be pretty devastating to our production here in the state of Colorado. And it's fun if you guys are Google Map people, it's fun to look at Cushing, Oklahoma on the aerial views. More $250,000 or quarter of a million barrel tanks than there are homes located down there. It's quite the place. So the conservation benefits of this new gathering system, which I should mention is really beyond our jurisdiction. We don't expect those. I guess that gets into somebody else's world, I guess. But I think it's interesting anyway. The conservation benefits are enormously reduced truck traffic, particularly the ongoing collection of oil. I mentioned this before, the reduced lease losses to evaporation and combustion, reduced geographic footprint. They can strategically place the production facilities with the horizontals and that sort of stuff. But this doesn't come easy. That's a pretty sophisticated system that took a lot of long-term planning to have a gathering system in place to make that happen. That's particularly difficult when you consider the volatility of the price of oil. It's either on or off. It makes long-term capital projects very difficult. So this, putting that kind of thing in requires developing the gathering infrastructure, investment, price stability, confidence issues, right-of-way, sale contracts. A lot of our contracts require the gauging of tanks. Currently, if you get the LAC unit, you can get out of that business of opening the tanks and that sort of thing. I think that was probably my last slide. And then there's some reference there. The numbers I used, particularly the ones I didn't laugh at. Anyway, very much a pleasure to be with you. This public speaking thing doesn't come very easy. Most of my social skills have to do with kind of bumping cattle with mud trucks. So hope I haven't offended anybody. And if there's any questions, we'd be glad to entertain.
Well, let me just say that was another lie, that your public speaking skills don't come out. It was an excellent presentation.
Oh, thank you.
A lot of thought obviously went into it. So,
yeah.
We're tossing around the word lie, but it was an exaggeration. Thank you. And I'm some of the numbers that you just presented to us, especially about you and your team's hard work on the number of inspections, very impressive. And I don't know that I was aware of them, so I really appreciate you bringing that to our attention in the context of the overall presentation. I bet there's other questions or comments. Commissioner Benton.
Just a comment, there are probably some of us in this room that drilled some of those wells that were old. Not you. And we thought we were doing a good job.
Oh, yeah, I think you were.
Well, thank you for the 180,000 miles and all of this presentation. All you do, Colorado. Presentation. Thank you. Very good. I think I will take that drive between Hudson and Kersey.
That's the old,
Hey, what do I do?
is that the old nuke plant that was converted?
And oil and gas.
That power plant, is that the old nuclear plant that was converted?
All right, well, our final agenda item for today, Greg Romulus here, our environmental manager. Matt, is there anything to tee this up, or we were forewarned is forearmed, and we heard this morning that he's going to be making this presentation. Looking forward to hearing and seeing, so thanks, Greg.
Thank you very much, and that's a hard act to follow, so hopefully you've got to freshen up on coffee. At any rate, thank you, Commissioners. Greg DeRomlo, Environmental Manager here at the Commission. And the agenda item says that I'm going to talk about the Wildlife Tracker tool. It's a little misleading. This is not going to help you on your next hunt. So I've actually changed it to the wildlife, the Form 2A Wildlife tab. Okay. Having a technical evaluation here. So just as a little background, starting in 2009, COGCC established sort of a dual permit system where we started utilizing, in addition to the APD, the application for permit to drill, the Form 2, which permits the downhole, the engineering of the hole, all of the stuff that Jeff and Craig just talked about below the surface. We also started utilizing the oil and gas location assessment, the Form 2A, and that's designed to permit the surface disturbances associated with the oil and gas development. And so what was shown on his aerial photos there is permitted through the Form 2A process. So my talk today is about a modification that we made recently to the Form 2A, and we added what we're calling the Wildlife tab. A little background to developing that tab. House Bill 07-1298, which is what was the impetus for the development of the Form 2A as a permitting tool, directed us to minimize adverse impacts on wildlife. It requires us to work collaboratively and in a consultative role with Colorado Parks and Wildlife, at the time called Division of Wildlife. Requires operators to avoid the most critical habitat areas, which we've designated as restricted surface occupancy areas, and set up the framework for those consultations on the oil and gas location assessments. Excuse me. It provided for best management practices to be established for the permits. As Matt mentioned earlier in the intro, there's some restrictions on how those get applied or how conditions of approval get applied to our permits. And so in order for us to slap a condition of approval on a permit, we actually have to have the landowner's consent. Sometimes that can be very challenging to get. Instead, we'll work cooperatively with the operator, and they will develop, in consultation with Parks and Wildlife, with us, with the surface owner, best management practices that they volunteer to conduct in order to be protective of wildlife. So that rulemaking happened in 2007 and was effective in 2009. There were a lot of other things discussed in those rulemakings as well. And then the work that we've done on the 2A for the Wildlife tab was further kicked into gear by an executive order from Governor Hickenlooper in 2015 called Conserving Greater Sage Grouse Habitat. And so with the potential listing of the greater sage grouse as an endangered species or threatened and endangered species, Governor Hickenlooper wanted to recognize the work that had been done by regulatory agencies, by landowners, by conservation groups, by ranchers, by oil and gas companies that had actually been successful at really protecting the habitat and the bird itself. And ultimately, we wanted to prevent the unnecessary listing of the greater sage grouse. So in that executive order, we were directed, and other state agencies were directed to coordinate with Colorado Parks and Wildlife on anything that might affect that habitat or that bird. We're required to track the consultations that were held, both on our 2A process and where CPW might have another nexus, let's say with Division of Mine Reclamation and Safety. We're directed to develop a Colorado habitat exchange to be used as compensatory mitigation when habitat was impacted by oil and gas activities. Track oil and gas activities and review the 1200 series rules, which govern operations in wildlife habitat. So this map obviously shows the state of Colorado. The shaded areas are mapped sensitive wildlife habitat, and I guess that's greenish. And then the more yellow color is restricted surface occupancy areas throughout the state. So two different types of wildlife habitat. And then just so you see where the greater sage grouse, that was really the thrust of that executive order, occur in the state, shows that. So that's, with that in mind, consultation with Colorado Parks and Wildlife happens at locations in half the state. Granted, not a lot of mapped habitat in Weld County, but it has been a pretty big deal since 2009, since those rules have been in place. So now getting into the meat, I'm gonna walk you through the tab that we developed, how it's gonna work both for the operators, for Parks and Wildlife, and for COGCC. And I've got a lot of slides, but really we're gonna just kind of bust through them. So stop me if you have any questions. So this is what the wildlife tab looks like when the operators are engaged with it. It's got a couple of questions pertinent to wildlife. Is this in a wildlife mitigation plan? This is a tool that operators and Parks and Wildlife can use to do advanced planning and advanced protection of habitat and mitigation. It provides an opportunity for Parks and Wildlife to do a pre-consult. So before we even get a permit in process, they can have had a consultation on the location, typically with the surface owner and the operator in Parks and Wildlife. And then the meat of the tab is this operator proposed wildlife BMPs, best management practices. So here they can pick the species that they want to take affirmative action for. They can pick the type of BMP. We have avoidance BMPs, minimization BMPs, and then mitigation BMPs. And that's sort of the hierarchical order of protecting sensitive species and sensitive habitat. And then they get to pick the language. And Parks and Wildlife developed for us a comprehensive list of all sort of their best management practices. This is what they believe to work best in most circumstances. So if they pick greater sage grouse from this list, they can pick a minimization BMP, and it's all drop-down driven, and they can go through this list, and maybe there's 3 BMPs or maybe there's 20 BMPs, and they can select the ones that work best for their operations and best for their plans. And they can add as many BMPs as they want, and then they also have the opportunity to, modify the language or write in their own. So if nothing that Parks and Wildlife proposed is going to work for their operational plan, then they can come in and write their own BMP. And then Parks and Wildlife gets the opportunity to consult on that. This is just what it looks like when it's on the PDF. So it's publicly available as the permit is in process. We have a public comment period on all our permits, as you're probably aware. And so the public can see this and say, well, gosh, I have some expertise in wildlife, and it looks like this is great, or it looks like they could do more. And so we could get a public comment, directly relating to the wildlife. So what does Parks and Wildlife do with that? When the operator submits their permit and they get the opportunity to review the BMPs, make a recommendation to COGCC, either adopt that BMP because it's just perfect. Maybe they want to modify the language a little bit, and if there were timing stipulations, maybe they feel like the timing wasn't appropriate. because some of the BMP language does have a place for the operator to actually insert the timing periods and some things like that. And then ultimately they can pass their task, which is just a routine administrative action that they take on the permit that essentially kicks it over to us. So they look at the same screen that the operators looked at. They can make a recommendation and they can add comments on each one. So here they could recommend that they modify what the operator proposed and they can put in their own comment here. The other thing that Parks and Wildlife can do is they can make recommendations on BMPs that the operator didn't provide. So this consultative role can be kind of iterative through the 40-day consult period. Parks and Wildlife can say the operator, didn't propose this BMP, and we think this is the best way to protect, let's say, greater sage grouse. And we can go back to the operator and say, hey, looks like you missed selecting this one. Is this one acceptable to you? The operator says, yeah, we were going to do that anyway. Okay, super. Let's get it on the permit. Let's get credit for giving those protections to the bird. COGCC process. We get to take the recommendations from Parks and Wildlife. We get to look at what the operator has provided. We have the benefit of the consultation process, which oftentimes involves the landowner, and then we can take the ultimate action on the permit. Hey, there's that tab again. Looks just the same for us as it did for the operator and for CPW. We will take and receive CPW's recommendation, and then we can either adopt it as a BMP or reject it. That's on the operator proposed, and it's a little bit different. Parks and Wildlife has proposed independent of the operator, because in that case, the action that we can take is either adopt as a BMP if the consultation has gone successfully and the operator says, yeah, sorry, I meant to put that on there. Adopt as a COA if we have worked with the landowner to allow us to put that condition of approval on, or we can reject Parks and Wildlife's recommendation because we couldn't get consensus on it, and we couldn't force that onto the landowner. And sometimes that is timing with the landowner or other issues that the surface owner may have an objection to what Parks and Wildlife is proposing for their land. And that wraps up the meat of my presentation, but I would like to make sure that I say not only thank you to you guys for listening to me after the really good presentation, I would also like to thank some folks for making this all happen, and that's Ginny Brannon and Madeline West at the Executive Director's Office. Ginny kicked this off a long time ago after the executive order, and then Madeline West kind of pushed it forward. And Kathleen Stacks, who is in the room, has also contributed a great deal to kind of kicking me in the pants and keeping it moving. John Holst and Michael Warren at Colorado Parks and Wildlife were instrumental in getting the list of BMPs established and getting some of the process checks done. Here in our office, John Noto and Dave Cabesco are OGLA supervisor and our Western OGLA specialist, so they are actively involved in that process. Ken Robertson and Ishin Lin made it all happen, and couldn't have done it without some help from oil and gas industry operators who were willing participants in the process. So that's, got any questions?
If I may, Mr. Chairman, please. Thank you very much. Appreciate that. I have sort of a step back general question. For those of us who were around in 2007, 2008, when the rulemakings were going on that kicked all this off, there was a good deal of concern and consternation about how much time would be added to the process and how rapidly all of these processes could be accomplished. Can you give me a thumbnail of how close we are to meeting the desired timelines that you were talking about? Do we usually, do we not usually?
Sure. So the rules establish a 40-day consultation period when a location is proposed in sensitive wildlife habitat. If I mentioned on the one slide where there's an opportunity for the wildlife mitigation plan, that's a tool that operators can use on a landscape level and work with Parks and Wildlife to really, and that is a tool that they've used to really streamline the process. Typically, the consultation on an independent oil and gas location proposal will take 40 days. There's on-site meetings, there's back and forth on the phone, there's trying to circle back with the landowner, and it bumps up against that 40 days. With wildlife mitigation plans in place, the CPW review becomes very perfunctory in that they take a look at it and say, yes, this is indeed contained within that wildlife mitigation plan. And the operator is proposing the adequate best management practices that we agreed on 2 years ago or 6 months ago or way back when. And this is consistent with that, and they pass the task relatively quickly. We do expect that this tool has the potential to maybe take some of those that are individual sites that would otherwise take 40 days. And if the operator selects the BMPs from that drop-down list and they're not making a bunch of crazy modifications to them, that Parks and Wildlife can see those and go, I recognize this BMP. It is what we believe to be the best practices, and we can pass this quickly. So I think that this may bridge that 4-day versus 40-day, and we'll see how that plays out.
Thank you.
Commissioner Bennett?
Commissioner Bennett?
It's a little bit off the subject, but there is a lot of this with respect to wildlife identification, of course, involves surveys. Has the state looked at anything in the use of drones and high resolution cameras to do some of those surveys as opposed to walking around?
I think the on-site consultation will continue. It's a valuable part of what we're doing. Because it gets us out there with the surface owner. On federal lands, we coordinate those with BLM typically. So I don't know that the on-sites will go away. I think where that has maybe a potential to have a bigger impact is maybe with the development and the refining of Parks and Wildlife's maps. The maps that I showed you are a part of our rules. And so they can only be updated through a rulemaking process. Parks and Wildlife would propose a change to us, and then we would go through a rulemaking process to update them. So I think that's where I could see that being pretty valuable.
And more along the line, and I agree that ultimately, particularly for location use and on-site, but use it for growth surveys to identify within the on-site to identify 3 or 4 places we need to spend a little bit more time. The on-site, maybe perhaps it'll short down, or with respect to pipelines.
I know that there's been some development with LiDAR, but I think they were flying it with helicopters. So I would think that would come along.
Well, another excellent presentation, and I know it reflects a lot of work from a lot of people, so thank you. And your acceptance, your Academy Awards acceptance speech, I know
Like that?
a lot of those folks.
Thank you.
But thanks goes to everybody involved. Director, anything else for the good of the order? Commissioner, same question.
Nothing here, Mr. Chairman.
Happy holidays, everybody. Be safe. Enjoy time with friends, family, and away from work. And we will see you all in Denver, January 30, 31. Okay, we are adjourned. Thank you, everybody.
Thank you, Mr. Chairman.